Okay, we are now live and on the record for Monday morning civil docket for May 23rd, 2022. And let me go ahead. Okay, Ms. Needwitz, which one?
Good morning, Judge. Priscilla Needwitz on behalf of Mr. Miguel Wise. We're number 33 on the docket.
Okay, one moment. CL 24121-I, Adolfo Sanchez versus Katia Melo. That's, you said 33?
Yes, Your Honor, that's correct. Yes, Judge, in this case, I believe we are here because we need dates for a trial setting.
Okay, so Mr. Galvan is no longer on this case?
Okay, let me write that down.
Is that the right case, Ms. Needwitz?
Yes, it is, Your Honor.
Okay, so then Mr. Wise represents who, the plaintiff or the defendant?
We represent the defendant, Your Honor. Ms. Medina Melo.
And so is Mr. Galvan still on the case?
I believe, as far as I know, yes.
Okay.
I haven't received anything.
All right. And so have you all already worked up the case?
No, Your Honor, I don't see any notes here that it has been mediated. I don't know, maybe we can get a DCC.
But is it ready for mediation already?
It should be, Your Honor, yes.
Okay. So, and when do you anticipate that you all can go ahead and file, get the mediation done?
Probably within the next 2 months.
Okay. Why don't we go ahead and do this?
Mm-hmm.
Let me see. We'll set this for a status on August the 29th.
Yes, Your Honor.
At 9:30. And then let's see if you can get it mediated between now and then. Do you think you all can agree to a mediator?
More than likely, Your Honor, yes.
Okay. So go ahead and get that mediated between now and then. And then at that time, we can go ahead and see if you all are ready to do a DCC.
Yes, Your Honor. And
Okay.
I believe that's all I have for today, Your Honor.
All right. Thank you.
Thank you. Have a nice day.
Likewise. Okay, Mr. De La Garza, what do you have?
Good morning, Your Honor. Number 20 on your docket.
CL 21-4040-I, Juan Rangel et al. Versus Allstate.
Yes, Your Honor. Good morning. Raul de la Garza on behalf of Allstate. Mr. Hector Bustos is a plaintiff's attorney. He is stuck in another court right now, but he did allow me to make the announcement in this one. We reached an agreement. It's their motion to compel mediation. We recently scheduled a reinspection and a deposition, and we agreed to mediate the case 90 days after the deposition of the plaintiff, which is tentatively set for August 24th, Your Honor.
Okay. All right, so then you'll come back on August 29th for a status at 9:30.
Will do, Your Honor. That's all I
Okay.
have. May I be excused?
Yes, sir. Thank
Good
you.
one.
Okay, Ms. Flores?
Yes, Your Honor, good morning. I have number 24 on the docket. And this case, Your Honor, is set for a motion for substituted service, and I've already filed a notice of appearance on behalf of the respondent, Your Honor, so there is no need for a hearing on that motion. I believe that
Okay.
Mr. Aguilar will share in that announcement.
Okay,
Yes. Sorry, Your
CL
Honor.
22-0422-I. Go ahead, Mr. Aguilar.
Yes, correct, Your Honor. This is Attorney Cesar Aguilar here on behalf of Leonel Hinojosa. I'm the one that filed the motion requesting substitute of service, and I do see that Ms. Flores, they filed the notice of appearance today, so there's counsel now, and they're making their appearance, Your Honor, so there's no need really to have this hearing no longer, Your Honor.
What kind of lawsuit is this? What are the grounds?
It's for a bill of review, Your Honor, on a divorce.
And Your Honor, I just received a copy of the bill of review about a week ago, so I'll be filing a response to that bill of review.
Okay. Well, I'm going to set you for status on August the 29th at 9:30 so that I don't lose it.
Okay.
Thank you, Your Honor. And I have nothing further, maybe excused?
Yes, ma'am.
May I be
Thank you.
excused as well, Your Honor?
Okay.
Yes,
Thank you, Your Honor.
thank you. Okay, Mr. Peña, what do you have?
Good morning, Your Honor. I also have a motion for substituted service. It's number 22 on your docket. Diana Sanchez versus Carolina Gonzalez et al.
Okay, one moment. CL 21-3535-I. Okay, and the grounds for the substituted service?
We don't know where the defendant is. We have made contact with her husband at her last known address, and I should say ex-husband. She's no longer there, but he's still in contact with her. He is in possession of the children, so she calls him on a regular basis. We'd like to leave a notice there with him so he can advise her as to the lawsuit. In the interim, we have tentatively reached a settlement with the defendant. Actually, the defendant's carrier, but we're waiting for finalization for that. So it doesn't fall through the cracks. We'd like to get her served, though.
Okay. All right. And that'll be granted, Mr. Peña.
That's all I have, Your Honor. May I be excused?
Okay, go ahead. Do you have that order on file?
Yes, I do, Your Honor. It should be on file.
Okay. All right, thank you.
Thank you, Your Honor.
Okay, Mr. Flores, what do you have?
Good morning, Your Honor. I have number 35 on the court's civil docket.
F 1738-21-9 in the interest of a minor child.
Abiel Flores, Your Honor, for the petitioner Eunice Barbosa. Judge, on this case, the court had allowed us additional time to submit the final order. This case has already been proven up. We were just waiting on some contractual issues, but those have been resolved. I submitted a final order this morning.
Okay, and that was signed off by all the parties?
Yes, Your Honor.
Okay. Then I'll go ahead and have it forwarded to my queue then, and that should take care of the case, correct?
That's correct, Your Honor.
Okay, I'll go ahead and sign off on it as soon as I receive it.
Thank you so much, Judge. I have nothing further. May I be excused?
Yes,
Thank you.
okay. Ms. Williamson, what do you have?
Good morning, Your Honor. I have F 3144-14-9 with Ms. Thompson and Ms. Carmen Ramirez. I don't see Ms. Carmen though.
Okay, do you know what number that is on the docket?
I'm sorry, Your Honor, they didn't print me a docket.
It's number 9, Your Honor.
Okay, thank you. Okay, that's in the interest of a minor child. All right, and what is the announcement?
Your Honor, I had filed a motion to waive mediation and the parties, well, Ms. Thompson's client wants to go to mediation. I just want to address that to the court to see which way the court feels compelled to go, whether we go to mediation or not.
Okay, Ms. Thompson, anything to add?
Yes, Judge. We did temporary orders mediation. The parties were reached an agreement for temporary orders and have been following the temporary orders for, I think, 2 years now. On top of that, anytime any issue comes up with Thanksgiving, summer, switching a weekend, we do it through Rule 11. I really think this is a case that can settle at mediation. I think the problem in the past has been it's been set and either the mediator cancels, we cancel, opposing party cancels, something comes up. But I don't think that's a reason to quote waive mediation. I think mediation is very helpful and it's very rare that I don't agree with it.
Your Honor, and I've got to agree with Ms. Thompson, though it was my motion to waive mediation, Your Honor. There's just been a lot of cancellations. I'm just asking to, we make an effort this time that mediation go forward.
Okay, who's the mediator?
So I believe it was Savannah Gonzalez, Your Honor.
Correct, Judge. I believe if I look back at my notes, the mediator has canceled once. We have canceled twice, and opposing party has canceled twice as well.
Okay. All right, well, I'm not gonna waive mediation, so just try to see if you can get with your schedules and move forward with the mediation. It's gonna happen, so try to get some good dates as to where you're really available and your clients are available. So just make it, speak to your clients, let them know that the next setting for the mediation is going to stick, so they need to make themselves available.
Your Honor, we have been exchanging dates. I think right now, Lucy, we're looking at July,
15th in the morning, Your Honor.
correct. So if we can
Yes.
have a setting after that,
Okay, August the 29th at 9:30. If you need something sooner to prove it up, let us know and we'll accommodate you.
thank you very much, Your Honor.
Thank you,
Okay.
Judge. May we be excused?
Yes,
Thank you. Your
Thank you.
thank you. Okay, Ms. Guerra?
Thank you, Your Honor. We have number 32 on the court's docket, Border versus Landstar. This is set for a status hearing. We've been ordered for mediation for, I think, the last month or two, and we just haven't seemed to be able to get it scheduled yet.
Okay, that's CL 2022-65-I. And Mr. Villalobos?
That's correct, Your Honor. If we need a mediate judge, I don't know if we already have a mediator, but I mean, I'm game. For whatever reason, we haven't been able to.
Yes, Your Honor. We have a court-appointed mediator, and we've just, there have been some issues hearing back from Mr. Villalobos's office. I understand that, of course, he's quite busy outside of just his normal practice. If perhaps he could suggest a different person in the office to speak to in case there's a new staff member that's handling his schedule, maybe that's the issue.
Judge, they can set it up with us in that.
I think that's who we've been dealing with, but we'll work on
Yeah,
that.
but I think it's been more my issue out of town all the time. But yeah, they can set it up, Judge, with us in that. I'll make sure they do.
Okay, well, I'm gonna order that this be mediated within the next 60 days and we'll come back on August the 29th.
Great, Your
Sounds
Honor.
good.
We have no
Madam-
further before the court. May we be excused?
Hey,
Yes,
Judge, I have number 16, if I can take care of it real quick.
okay. Yes, Miss, okay. CL 163067-I, Fidel Rangel versus Grupo GRUPO, Avapal, AVAPAL. Okay, is Mr. Guerrero present?
I do not know.
Oh, he's just logging in. Let me let him on. Mr. Guerrero, can you hear me?
Yes, I can. Yes.
Okay, we're on your case right now. On number 16, Fidel Rangel versus Grupo Avapal.
Yes, yes, Your Honor.
Okay, and what is the announcement on this case?
Well, we had it set for, I think, trial. We're ready to go to trial on this one. Ed and I had conferred on this one. We weren't able to resolve it. And this,
That's correct, Judge, and I would be willing on this one to even do a bench trial if they're okay with it, because it's a real old case and we just need to get rid of it.
Have you all submitted the DCC?
I don't even remember, Judge.
what was it? That's a good question, Judge. We haven't even gone to mediation. I don't think we've gone to mediation. Have we gone to mediation? Have you?
This case is so old, I don't even know.
Yeah. So Judge, I'll talk to my client about doing this by bench to make it faster. So I mean, the sooner we try it, the better. Not because I want to get rid of it. I just think it needs to get adjudicated.
Go ahead and file an order setting a DCC and indicate whether it'll be a jury trial or a bench trial so that we can be prepared with dates and then you'll get set up.
Thank you, Your Honor.
Appreciate it. Can we be excused, Judge?
Yes.
Thank you, Your Honor. Have a good day.
Okay, thank you. All right, Mr. Ramirez, what do you have?
Yes, good morning, Judge. I have number 3 on your docket. It's yes, ma'am.
I'm sorry, F0453-21-9 in the matter of the marriage of Nayeli, Nayeli, Faisal, Faisal versus Luis Faisal.
Yes.
Good morning, Your Honor. Catarina Alvarado on behalf of the respondent, Mr. Luis Faisal.
Yes, and Daniel Ramirez representing Nayeli Faisal, Judge.
Okay, and what is the announcement?
It's set for a final hearing today, Judge. We're getting very close to resolving the last of couple of issues. And both Ms. Alvarado and I came to the conclusion that we're going to be needing at least another resetting of our final hearing, Judge. Maybe 2 to 3 weeks. Ms.
Okay.
Yes, Judge, if we can have something in the next 2 weeks, we're very close. We've been circulating a proposed decree between our clients, and we hope to have gotten it done by this morning, but we weren't able to, Your Honor. So if we could have 2 weeks, I think that would be sufficient.
Okay. Would June the 6th at 1:30, would that work?
That works for me, Your Honor. I don't know if.
Mr. Ramirez?
I have a conflict in the afternoon, Judge.
Okay.
It would not work for me.
Okay, then it'll be June 13th at 9:30.
All right. That should give us plenty of time, Judge.
All right. Anything else?
No, ma'am.
Not on this case, Your Honor. I saw, Judge, I'm listed as an added item on number 11 on your docket.
Okay. Mr. Ramirez, do you have anything else?
No, ma'am. May I be excused?
Yes, sir.
Thank you, Judge.
Okay, you're welcome. Okay, Ms. Olivares notified us that she is stuck in an in-person hearing. So she is not available at this time. It'll be later on in the docket that she'll be available.
Judge, I don't believe my presence is necessary. I did review, I believe it's a child support arrears issue. I'm not 100% sure, but that's what I saw on there. Judge, I've had no, back in 2019, we suspended visitation because Dad had been charged with a new offense. And I believe since then his attorney's withdrawn. I don't think it's a visitation issue. I believe it's child support arrearages.
Okay.
So may I be excused, or would you like me to wait for Ms. Olivares?
No, for that, it's fine.
Thank you, Judge.
You're excused. If for some reason something changes, we'll notify you.
Thank you, Judge. May I be excused?
Yes, ma'am.
Thank you.
All right, Mr. Hernandez, what do you have?
Good morning, Judge. How are you doing today?
Thank you.
Docket number 21, Judge. Motion for substituted service.
CL 23-026-I, LNR Ready Mix versus Holchemont et al. Okay, go ahead.
Yes, Judge. Jose Hernandez here on behalf of LNR Ready Mix LLC. Judge, here in a motion for summary judgment. The process server has tried to serve Mr. Cepeda on 3 separate occasions. On 2 of the occasions, his assistant identified that it is his office, but he was not available. So therefore, we're asking at this time that the court allow us to drop off the copy of the petition there at his business office, Judge, and that would satisfy the service of the lawsuit.
Your Honor, Rolando Cantu here on behalf of Filigonia, and we'd be willing to accept service, Your Honor. That's not a problem for Filigonia.
Well, it's not for Filigonia, it's Mr. Cepeda. It's for Pedro Cepeda.
I would be willing to accept service for Pedro Cepeda.
Okay.
And Judge, if the court allow, I will send over to Mr. If Mr. Cantu will allow it, fax it over, email it to his office, and that'll be the service sufficient to start the 20-day answer date, Judge.
I would have no problem with that, Your Honor. If he could email it, I'd appreciate it.
Will do, Judge.
Okay, no problem then. Anything else, Mr. Hernandez?
I have nothing further, Judge.
Okay.
Your Honor, I have number 30.
Okay.
It's a quick announcement. To my knowledge, they're still in bankruptcy.
Okay, CL 162175-I, Mission Vacuum and Pump Truck Services versus Texas E&P Funding.
Yes, Your Honor. And if I'm not sure if we're still in bankruptcy, but I've got to get permission from the trustee to try to get a default judgment on these people because they haven't appeared. We haven't heard from them.
Okay.
If the court would like, we just debate it till we hear otherwise from bankruptcy counsel.
Okay, so you haven't had any contact with the bankruptcy counsel?
No, Your Honor. Well, bankruptcy counsel, yes. It's Mr. Villeda. And so let me talk to him again and see what he says.
Okay. Would you be able to do that before the August 29?
I will. I will be happy to do it, Your Honor.
Okay, August 29th at 9:30.
Very well, Your Honor. I do not have anything, sir. Further, may I be excused?
Yes,
Thank you. You have a great day and stay safe.
thank you. You too.
Bye-bye.
Okay, Ms. Abreu, what do you have?
Your Honor, I have number 28 on the docket. Motion to withdraw.
Okay, CL 195839-I, Joel Ortiz versus Carmen Azoka, AZOCA.
Yes.
Okay,
We're seeking to withdraw. There's been breakdown in the relationship with the council such that we don't feel like we can continue representing this client, and we seek to withdraw.
okay. And this is, you represent Joel Ortiz, correct?
Correct.
Okay, Joel Ortiz, is Mr. Ortiz present? All right. Okay, then your motion to withdraw will be granted. Is there an order on file?
Yes, there is.
Okay, we'll go ahead and have that forwarded to our queue.
Okay, thank you, Your Honor. That's all I have this morning. May I be excused?
Yes.
Thank you.
Okay, and Ms. Rivera Barlas?
Yes, Your Honor. I'm here on number 27 on your docket on behalf of the defendant.
CL 221131-I, Veronica Chavez versus Allstate.
Yes, Your Honor. This is plaintiff's motion to compel mediation. Mr. Victor Rodriguez was on the Zoom hearing, but he notified me that he was also in a deposition. And so he and I agreed to make this quick announcement that we've agreed to mediate within 120 days.
Well, it's a fairly new case, correct?
Yes, so on these cases, I mean, it's a storm case, a simple one. We usually do a reinspection and a deposition of the plaintiff. That usually will take us about 4 months, but even if it's not 4 months, usually Mr. Rodriguez's office is pretty good to extend it just to get those two things taken care of.
Okay, October 10th at 9:30.
Okay, Your Honor, October 10th. And I'll relay this information to Mr. Rodriguez.
Okay.
Thank you, Your Honor. That's all I have before you. May I be excused?
Yes.
Thank you.
You're welcome. Mr. McInnes?
Good morning, Judge. We're here at number 34 on the docket.
CL 211711-I, GEM Enterprises versus WBL SPE the third LLC.
Kelly McInnes for the plaintiff, Your Honor.
James Cuellar for WBL.
Okay, the announcement?
Our announcement is this is a case where we've started the mediation process. We got close to settling, but the mediator had to end the mediation at the time. We've had a couple of times where we scheduled the follow-up mediation, but there have been personal emergencies and scheduling issues. So we're still waiting to get the thing completed without forgetting our mediator, Judge.
And have you all gotten alternate dates so that you can go back soon?
This time we haven't agreed on a final date yet, Judge. We'll do that here shortly.
Mr. Cuellar, do you have any issue in trying to get this mediated within the next 60 days?
No, Your Honor. At the present time, I think the ball was in the mediator's court to give us some dates. So either me or Kelly will follow up with the mediator to get those dates.
Okay, please notify him that he needs to give you some dates so you can go back within the next 60 days and you'll come back on August the 29th at 9:30.
That's all we've got before the court, Your Honor. May we be excused?
Yes.
Have a great day, Judge.
Thank you. Mr. Davis?
Good morning, Judge. I have number 1 and number 13 on your docket.
F 3894-18-9 in the matter of the marriage of Omar Contreras versus Celia, CELIA Soto.
Yes, Judge, I represent Mr. Contreras, the petitioner. It's set for your default divorce.
Okay, and Ms. Soto was properly served?
Yes, ma'am, she was.
Via personal service?
Yes.
Okay, and no answer was filed.
That is correct.
Okay. And is your client on?
He's on. I think he will need an interpreter though.
Okay. Ms. Castaneda, can you please ask Omar Contreras to unmute themselves?
Omar Contreras, por favor, prende su micrófono.
Omar Contreras?
Yes, he's unmuted.
Okay. Let him know, Ms. Castaneda, that he'll need to speak up and have him raise his right hand.
¿Necesita hablar más fuerte, señor Contreras? Por favor, levante su mano derecha.
Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth?
Jura que el testimonio que va a dar es la verdad, toda la verdad y nada más que la verdad.
I'm sorry, I couldn't hear him. Have him
No lo
repeat that?
escuchamos. Sí. Yes.
Okay. Tell him to lower his hands.
¿Puede bajar su mano?
All right. Go ahead, Mr. Davis.
Thank you. Mr. Contreras, prior to filing this petition for divorce, you had lived in the state of Texas for at least 6 months and Hidalgo County for at least 90 days, correct?
Antes de meter esta petición, usted era residente del condado del estado de Texas por los precedentes 6 meses y el condado de Hidalgo por los precedentes 90 días, ¿correcto? Sí. Yes.
And you were married to your wife, Celia Soto Torres, in 2003, and you and her have been separated since 2006, correct?
Y usted estaba casado con Celia Soto, se casó con Celia Soto en el 2003 y han estado separados desde el 2006, ¿correcto?
Correcto, sí.
Correct, yes.
And the marriage between yourself and your wife has become insupportable due to a discord or conflict of personalities, and there's no reasonable expectation of reconciliation, correct?
Y han estado separados por insoportabilidad y no hay expectación de reconciliación, ¿correcto?
Correcto, sí.
Correct, yes.
Okay. And you have 2 children that were born from the marriage that are under the age of 8, minor children, correct? That have not emancipated.
Tienen 2 niños menores, ¿correcto?
No.
¿No?
One is 18, but is not emancipated yet.
Uno tiene 18, pero no se ha emancipado, ¿correcto?
19.
19.
Okay. And y'all previously, you and your wife, there's a previous order in a attorney general case that reflected all the issues regarding conservatorship and child support of your children, correct?
Y hay una orden con la Procuradora General que ya tenía los datos de los niños, ¿correcto? Tocante las... Yes.
Okay. And Judge, for the record, that case has already been consolidated into this case with the prior order.
Okay.
Mr. Contreras, with regards to any property that you and your wife may have, y'all do not at this point own any joint property, correct?
Señor Contreras, al tocante la propiedad, ustedes ahorita no tienen propiedad conjunta, ¿correcto?
And you're asking that whatever property you have in your possession be awarded to you, and whatever property is in her possession be awarded to her, correct?
Y usted está pidiendo que cualquier propiedad que usted tenga en su nombre se le otorgue a usted y cualquier propiedad que ella tenga se le otorgue a ella, ¿correcto?
Sí.
Yes.
And the same thing for any debts. Any debts that you may have will be assigned to you, and any debts that she may have will be assigned to her, correct?
Y lo mismo tocante a deudas, cualquier deuda que usted tenga a usted y cualquier deuda que ella tenga a ella, ¿correcto?
Sí, sí.
Yes.
Okay, and you're asking the court to grant your divorce, correct?
Y usted está pidiéndole a la corte que le otorgue el divorcio, ¿correcto?
Sí.
Yes.
Judge, that's all the testimony we have.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically that proper service was tendered on Ms. Soto, no answer, has been on file, and this petition has been on file for the required amount of time. The court is granting the relief as requested on the record. And Mr. Davis, is there a divorce decree already on file?
I do not believe that so, Judge, but we'll get one submitted shortly.
Okay, so I'm gonna set a tickler for June the 10th, just to make sure that it's been submitted by that time.
Yes, ma'am.
Okay. All right, anything else?
Nothing further on this case, Judge.
Okay, let him know, please, that he is excused, Ms. Castañeda.
Mr. Contreras ya se puede retirar.
Yes.
Thank you.
All right, your next case?
Judge, that was number 13 on your docket.
F 4767-21-9 in the matter of the marriage of Jorge Carizales versus Jacqueline Escalante.
Good morning, Your Honor. Samuel Reyes for Jorge Carrizales petitioner.
Tim Davis for Ms. Escalante.
And what is the announcement?
Judge, we have an agreement. We have approval subject to the court's approval, Your Honor.
That is correct.
Okay, and Jorge Carizales and Ms. Escalante, are they present?
Ms.
Yes, Your Honor.
Escalante is here.
Okay, and is Mr. Carizales English speaking or Spanish speaking?
He's an English speaker, Your Honor.
Okay, Jorge Carizales and Jacqueline Escalante, please announce yourselves.
Jorge Carrizales, present, Your Honor.
Jacqueline Escalante, present, Your Honor.
Okay, can I please have both of you raise your right hands? Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth? Mr. Carizales, yes or no?
Yes, Your Honor.
And Ms. Escalante, yes or no?
Yes, Your Honor.
Okay, you may lower your hands. And who will be proving it up?
I can proceed, Your Honor. We're petitioners.
Okay, go ahead with Mr. Carizales.
Okay. Mr. Carrizales, please state your full name for the record.
Jorge Luis Carrizales.
And sir, you recall that on or about January 3rd that we mediated this case and we arrived at a mediated settlement agreement, correct?
Yes, correct.
Okay. And at this time, you are asking that the court approve that mediated settlement agreement, correct?
That is correct.
Okay. And as part of that mediated settlement agreement, you all will be joint managing conservators with mom being primary, correct?
That is correct.
And you as the father shall have visitation with the children every day that you're home from work with a 48-hour notice of the days that you will be arriving and returning to work, correct?
That is correct.
And your understanding is that said visitation period shall not exceed 3 days in a row, correct?
That is correct.
And your pickup will be after school or 10 a.m. if the children are not in school until 8 p.m., correct?
That is correct.
And when Jimena turns 3 years old, your visits shall also include overnight visitation as set out above if you're still working out of town, correct?
That is correct.
And if you're working in the Rio Grande Valley, you shall have standard visitation, but there shall be no overnight visits until Jimena is 3 years old, correct?
Correct.
And drop off on those nights will be at 8 p.m., is that right?
That's right.
And you've agreed that holidays shall be as per the Texas Family Code, correct?
That is correct.
And for 2022, the parties shall not exercise spring break or summer visitation. Is that correct?
Correct.
Okay. And you agree that you will work out the date and time for pickup and drop off if the time above does not work for the children due to daycare/school conflict, correct?
That is correct.
And when you are in possession of the children, you shall take the children to school and or daycare/Head Start, and you shall make sure the children attend their therapy and doctor appointments, correct?
That is correct.
And you've also agreed that in the final order, there will be injunctive language preventing the parties from speaking about each other in a disparaging, vulgar, or offensive manner, correct?
That is correct.
And you shall keep and pay for the 2016 Ford F-150 Lariat motor vehicle, correct?
That is correct.
And you shall refinance that vehicle by July the 30th, 2022, correct?
That is correct.
and you will make all payments timely. And if you fall more than 30 days behind, then you shall surrender that vehicle to Ms. Escalante until you become current on your payments, correct?
That is correct.
Additionally, you will have up to 15 minutes between 6 p.m. and 8 p.m. for video or telephonic access with the children, correct?
That is correct.
When you're not in possession. However, the children can communicate with the other parent as they wish within reasonable time periods, correct?
Correct.
Additionally, the children's residence shall be restricted to the state of Texas, right?
Right.
And child support that you will be responsible will be $750 a month beginning February 1st, 2022, correct?
Correct.
And you owe retroactive child support in the amount of $2,500, which you will pay off at a rate of $100 per month beginning February the 1st, 2022, correct?
That is correct.
And Ms. Escalante shall have the right to claim the children on the income tax returns, correct?
Correct.
And as part of this agreement, you understand that Ms. Escalante will apply for medical benefits with the state of Texas, and you are to reimburse $95 to the state of Texas for medical and $5 for dental per month. And any reasonable healthcare expenses not covered by insurance will be equal responsibility of both parties, 50-50. Do you understand that?
Yes, correct.
Okay. And at this time, you're also want to bring it to the court's attention that that you are asking Ms. Escalante not give out your mother's information and your mother's number to other strangers, correct?
That is correct.
Okay, and this is the full settlement agreement, mediated settlement agreement that you entered into, correct?
Correct.
And you're asking to the court to approve this settlement agreement and to grant this divorce, correct?
Yes, that is correct.
I'll pass the witness, Your Honor.
Judge, I don't have any questions for this witness.
Okay, do you have any of your clients?
Yes, just real quickly.
Go ahead.
Ms. Escalante, you've heard the terms of the mediated settlement agreement that were read. Are you in agreement with those terms?
Correct.
Okay, and with regards to your children, do you believe those terms are in the best interest of your children?
Yes.
Okay, and with regards to the division of the marital property, do you believe that is a fair and equitable division of the marital estate?
Yes.
Okay, and you're also asking the court to approve the agreement and grant your divorce, correct?
Yes.
I'll pass the witness, Judge.
Okay, Mr. Reyes, do you have any questions of Ms. Escalante?
No, Judge, I have nothing further, and this time we'll rest and close.
Okay, anything else, Mr. Davis?
No, Judge, that's all.
All right, then the court is taking judicial notice of all the documents in the court's file and is granting the relief as requested and testified to on the record. And is there a divorce decree that has been circulated for signatures?
Judge, I did receive a proposed divorce decree from Mr. Davis this morning, just asking to have a little opportunity to review that. We should get it on file, signed by everyone by this week, Your Honor.
Okay, then we'll go ahead and I'm going to set a tickler for June the 10th. So please have it in by June the 10th.
Will do, Your Honor. Judge, I have nothing further this morning, Your Honor. May my client and I be excused?
Yes, sir.
Thank you, Judge. Have a great day.
Likewise. Mr.
Same
Davis?
thing here, Judge. That's all I have. May be excused.
Yes, sir.
Thank you.
Thank you. Mr. Ornelas, what do you have?
Number 4 on your docket, Your Honor.
F0472-22-9 in the matter of the marriage of Pablo Mejia versus Teresa, Teresa Ochoa.
That is correct, Your Honor. This is a default divorce. We're ready to proceed, but we need an interpreter, Your Honor.
Okay, so
The respondent was served on February the 11th, and there's no answer of record, Your Honor.
and she was served via personal service?
That is correct.
Okay. Ms. Castañeda, please have Mr. Mejia raise his right hand.
Señor Mejía, por favor, levanta su mano derecha.
Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth?
Jura que el testimonio que está a punto de dar es la verdad, toda la verdad y nada más que la verdad.
Yes, ma'am.
Okay, let him know that he needs to answer in either English or Spanish, and he can lower his hand.
Puede bajar su mano, Mr. Mejía, pero va a contestar en inglés o en español.
Español.
En Spanish.
Okay, go ahead.
Thank you, Your Honor. Is your name Pablo Mejia?
¿Su nombre es Pablo Mejía?
Pablo Mejía. Es el,
Pablo
Are you the one who filed this petition for divorce?
¿Es usted el que metió esta petición de divorcio?
yes,
En español, por favor. Sí.
sí,
Yes.
Are you telling this court that before you filed this petition for divorce, you were a domiciliary in the state of Texas for 6 months and a resident of this county for 90 days?
Okay. Antes de meter esta petición, usted era un domiciliario del estado de Texas por los precedentes 6 meses. Y, yes,
And you were married on or about 2002?
y usted se casó como en el 2002.
sí,
Yes.
And you separated on or about October the 9th, 2021?
Y se separaron como el 9 de octubre del 2021.
yes, man,
En español, por favor, señor Mejía.
yes,
En español, señor Mejía.
sí,
Yes.
All right. The reason for your separation was because there was a discord or conflict of personalities between you and your spouse.
La razón de la separación era porque era discordios o conflictos en personalidades entre usted y su esposa.
sí,
Yes.
And this destroyed the marriage relationship?
Y esto destruyó los fines maritales. Yes.
yes,
Is there any expectation of reconciliation?
¿Hay alguna expectativa de reconciliación?
no,
No.
Were there any children born during this marriage?
¿Hubo niños que nacieron de este matrimonio?
no,
No.
Were there any children adopted during this marriage?
¿Hubo niños adoptados de este matrimonio?
no,
No.
Is your wife expecting a baby?
¿Su esposa está esperando bebé?
no,
No.
And basically, as far as the division of the community estate, there's 2 properties involved. One is a lot and the other is a mobile home. Is that correct?
Y tocando a la propiedad comunal, uno es un lote y una es un casa móvil.
sí,
Yes.
You're asking this court that you keep a lot, which is described as Lot 1 Doffing subdivision. Is that correct?
I missed the subdivision number, Mr. Ornelas.
Lot 1 Doffing, D-O-F-F-I-N-G.
Okay, y usted está pidiéndole a la corte quedarse con el lote que es el lote 1 en la subdivisión de Dauphin.
que se quede ella con la traila y yo pues me
She's
quedo
keeping the
libre.
trailer.
Yes, but she's going to keep the trailer and you're going to keep the lot. Is that correct?
Ella se va a quedar con la trailer y usted se va a quedar con el lote, ¿correcto?
Sí, correcto.
Yes, correct.
She's going to keep whatever other personal property she has in her possession. Is that correct?
Y ella se va a quedar con cualquier otra cosa personal que ella tenga, ¿correcto?
Sí, correcto.
Yes, correct.
She's going to pay whatever debts are in her name and you're going to pay whatever debts are in your name. Is that
Y ella
correct?
va a pagar cualquier deudas que ella tenga en su nombre y usted cualquier deudas que tenga en su nombre, ¿correcto?
Sí, sí,
Yes.
And you're asking this court for a divorce?
Y usted está pidiéndole a esta corte un divorcio.
sí,
Yes.
No further questions, Your Honor.
Okay. The court is taking judicial notice of all the documents in the court's file, specifically that she was served properly. No answer has been on file. And granting the relief as requested and testified to on the record. Do you have a divorce decree?
We will be filing that today, Your Honor, along with the certificate of last known address and the non-military affidavit.
Okay, perfect. All right, anything else?
No, Your Honor. Thank you.
Okay, thank you.
Yeah.
Okay. All right, Mr. Flores, what do you have?
Good morning, Your Honor. I have number 6 on your docket. It's a
Yes.
default divorce.
Okay, F0748-22-9 in the matter of the marriage of Yvonne Mendoza versus Juan Perez.
Yes, Your Honor. Georgia Flores, on behalf of the petitioner, Ivan Mendoza. Mr. Perez was served on March 2nd of this year, and he was served personally. No answers on file, and more than 10 days have elapsed since the return was filed with the court.
Okay, and is your client present?
Yes, Your Honor. She will need services of your interpreter.
Okay, Yvonne Mendoza.
Aquí estoy.
Okay, Ms. Castañeda, please ask her to raise her right hand.
Por favor, levante su mano derecha.
Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth?
Jura que el testimonio que está a punto de dar es la verdad, toda la verdad y nada más que la verdad.
Sí.
Yes.
Okay, she may lower her hand.
Puede bajar su mano.
You may proceed.
Thank you, Your Honor. Please state your name for the record.
Por favor, diga su nombre.
Ivonne Mendoza.
Iván Mendoza.
And you're married to Juan Carlos Perez, is that correct?
Y usted está casado con Juan Carlos Pérez, ¿correcto?
Sí.
Yes.
Prior to the filing of this petition for divorce, did you reside in this county and state for at least 6 months?
Antes de meter esta petición, usted vivía en este estado y condado por los precedentes 6 meses.
Sí.
Yes.
You got married on or about March the 23rd, 2012, and separated on or about September 2021.
I didn't get the separation date, Mr. Flores.
September 2021.
Que usted se casó en marzo del 2011,
2012.
Marzo del 2012 y se separaron en septiembre del 2021.
Sí.
Yes.
You're asking for divorce because your marriage has become insupportable due to conflict of personalities that destroys the legitimate ends of your marital relationship.
Y usted está pidiendo un divorcio por conflictos de personalidades.
Sí.
Yes.
You're also asking for divorce because you have been a victim of domestic violence. Is that right?
Y también está pidiendo un divorcio porque ha sido víctima de violencia doméstica.
Sí.
Yes.
In fact, he pled guilty to assaulting you on or about August of 2020. Is that right?
Él tuvo una súplica de culpable en agosto del 2020.
Sí.
Yes.
That was out of county court in law number 7 here in Hidalgo County.
Y esto fue de la corte número 7 aquí del condado de Hidalgo.
Sí.
Yes.
He's been, right now he's currently in jail, is that correct?
Y ahorita él está en la cárcel, ¿correcto?
Sí.
Yes.
He's been arrested around 10 times for, I think 2 times for driving while intoxicated, also for possession of drugs and all other kinds of criminal actions. Is that right?
Que él ha estado arrestado como unas 10 veces, 2 por manejar intoxicado y posesión de drogas y otras actividades criminales, ¿correcto?
Sí.
Yes.
You think that you and Mr. Perez will get back together?
¿Usted piensa que usted y el señor Pérez se van a volver a juntar?
No.
No.
During this marriage, you had 4 children. Valeria, born October 25th, 2012.
Durante el matrimonio tuvieron 4 hijos. Valeria, que nació el 25 de octubre del 2012.
Sí.
Yes.
Juan Carlos, born August 13th, 2014.
Juan Carlos, que nació el día 13 de agosto de 2014.
Sí.
Yes.
Noel Perez, born August 17th, 2016.
Noel Pérez, nacido el 17 de agosto del 2016.
Sí.
Yes.
And Damian, born on November the 2nd, 2017.
Y Damián, nacido el 2 de noviembre del 2017.
Sí.
Yes.
You're not currently pregnant, are you?
En este momento no está usted esperando, ¿correcto?
No.
No.
You're asking this court to appoint you sole manager conservator of the children?
Está usted pidiéndole a la corte que la apunte única manejadora de los niños, ¿correcto?
Sí.
Yes.
And that Mr. Perez have visitation rights pursuant to the Texas Family Code.
Y que el señor Pérez tenga visitaciones debido a las leyes del estado de Texas, ¿correcto?
Sí.
Yes.
In terms of child support, he'll be paying you $380 per month starting June 1st, 2022.
Y tocante a la manutención, el señor le va a estar pagando 380 por mes, comenzando el día 1 de junio del 2022.
Sí.
Yes.
And when that child turns 18 or graduates from high school, it will be lowered to $326 a month.
Y cuando el niño, su hijo gradúe, va a bajar a 326 al mes.
Sí.
Yes.
And then when that child graduates or turns 18, it'll go down to $272 a month.
Y cuando ese hijo gradúe o termine la escuela, va a bajar a 272 al mes.
Sí.
Yes.
And finally, after all the three kids have graduated and from high school turn 18, it'll go down to $217 a month.
Y cuando todos los niños gradúen, va a bajar a 217 al mes.
Sí.
Yes.
The children are currently under Medicaid, is that right?
¿Los niños ahorita tienen Medicaid?
Sí.
Yes.
You understand that Mr. Perez will be paying $100 to the state of Texas for Medicaid.
Y usted entiende que el señor Pérez va a estar pagando $100 para el estado para el Medicaid.
Sí.
Yes.
He also owes you retroactive child support from the date of separation in the amount of $3,420.
Y también el señor le debe retroactivo dinero del child support de $3,420, ¿correcto?
Sí.
Yes.
And he'll be paying you that in the amount of $75 per month on top of the current child support.
Y le va a estar pagando eso a $75 por mes, aparte de lo que ya le va a estar pagando de la manutención, ¿correcto?
Sí.
Yes.
During this marriage, you and Mr. Perez did not accumulate any kind of community property other than personal effects.
Durante el matrimonio, usted y el señor Pérez no acumularon propiedad comunal, ¿correcto? Aparte de sus cosas personales.
No.
No.
You're asking this court to award you whatever you have in your possession and to award Mr. Perez whatever he has in his possession.
Usted le está pidiendo a la corte que le otorgue a usted lo que usted tiene en su posición y el señor Pérez lo que él tenga en su posición.
Sí.
Yes.
In terms of debts, you'll keep whatever you have, in, whatever debt you have, and Mr. Perez will keep whatever debt he has.
Tocante a deudas, usted se va a quedar con las que usted tenga y el señor Pérez con las que él tenga.
Sí.
Yes.
You're also asking this court to enjoin him from communicating with you at all time of the day or night, threatening you, disturbing the peace of the children and you.
Y también está usted pidiéndole a la corte que él que no se comunique con usted, dejarla en paz en el día, en la noche, que no tenga comunicación con usted.
Sí.
Yes.
And not coming around your house, I think within 200 feet, other than to exercise visitation privileges.
Y que no venga en su propiedad, su casa, por menos de 200 pies, a solo que sea para la visitación.
Sí.
Yes.
And that he not be allowed to consume alcohol or any controlled substances within the 24 hours before or during the period of possession of the children.
Y que no tome alcohol ni consuma cualquier sustancia controlada por 24 horas de la visitación.
Sí.
Yes.
You're asking this court for divorce.
¿Y usted le está pidiendo a esta corte un divorcio?
Sí.
Yes.
That's all I have, Your Honor.
Okay, the court is taking judicial notice of all the documents in the court's file, and specifically that Mr. Perez was properly served. The required amount of time has already passed. And Ms. Mendoza is not requiring a name change, correct?
No, Your Honor.
Okay. And how much time do you need in order to, so is the divorce decree is already on file, correct?
Yes, Your Honor.
Okay. I'll ask for that to be forwarded to my queue, and I'm granting the relief as requested and testified to on the record.
Thank you, Your Honor.
Okay, anything else?
That's about it. Thank you so much. May we please be excused.
Yes, sir. Thank you. Okay, let her know that she's excused, Ms. Castañeda.
Ya se puede retirar, Ms. Mendoza.
Gracias.
Thank you.
Okay, Ms. Gutierrez? Lisette Gutierrez.
Hi, yes. I believe it's docket number 7.
Is that F0818-22-9 in the matter of the marriage of Lisette Gutierrez versus Jose De Leon?
Yeah.
I'm sorry?
Yes, Your Honor.
Okay, and is Mr. De Leon, I'm sorry, going to be on this morning?
Yes, he is present.
Is
Yes,
Mr.
Your
De
Honor.
Leon, can you hear me?
Yes, Your Honor.
Okay. Let me go ahead and pull this up. And both of you are representing yourself, Ms. Gutierrez?
Correct.
Okay, have you prepared a divorce decree?
We have not, Your Honor.
But you have no children, and do you have any community property?
No, we do not.
So nothing was purchased of like real estate or anything like that when you all got married?
No.
So you all were only married for, or stayed living together for about 3 months?
Correct.
Okay. Go ahead and raise your right hands. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth? Ms. Gutierrez, yes or no?
Yes.
Mr. De Leon, yes or no?
Yes.
All right, you may lower your hands. Okay, Ms. Gutierrez, please state your full name for the record.
Lisette Gutierrez Cabrera.
And you're currently married to Jose De Leon, is that correct?
That is correct.
And at the time that you filed for divorce, you were a domiciliary of Texas for at least 6 months and a resident of Hidalgo County for at least 90 days?
Yes.
You were married on or about September 9, 2019, and ceased to live together as husband and wife on December 1st, 2019?
That is correct.
And your marriage has become insupportable because of discord or conflict of personalities between yourself and your husband that destroys the legitimate ends of the marriage relationship. Is that correct?
Correct.
At this time, is there any reasonable expectation of reconciliation?
No.
And are you expecting any children of this marriage at this time?
No.
And you and your husband do not have any minor children together, is that correct?
That is correct.
In fact, you have no children together, is that correct?
That is correct.
And is it your testimony today that you have no community property?
Yes.
Okay. And so are you asking the court for you to stay with any personal property in your possession, any debts under your name as well?
Yeah, so it's mine is, I guess, staying under my name, and yeah, we don't share anything.
All right. All right, Mr. De Leon, you've heard the testimony by your wife, is that correct?
Yes.
Is that your same understanding?
Yes.
Okay, and so you will be staying with any debts that are solely incurred by you and under your name and any personal property that you have in your possession, correct?
Correct.
Okay. And you will need to be submitting the divorce decree. So the court is taking judicial notice of all the documents in the court's file. And I am granting the relief as requested on the record and granting the divorce. And you do have until June the 10th to turn in that divorce decree.
Judge, if I may,
go ahead.
There is a divorce decree filed back from March the 31st.
Okay, does it reflect what they testified to on the record?
No children, no property. No name change.
Okay, go ahead. And is that signed by both of them?
Yes, it is.
Okay, go ahead and have that forwarded to our queue.
Yes, ma'am.
Okay, apparently you all did file one on March 31st, so I'll just have that forwarded to my queue and I'll go
Okay.
ahead and sign off on it.
Okay, thank you, Your Honor.
Okay, anything else?
That's all.
Okay, good luck to both of you.
Thank you.
Okay.
May we
Uh,
be excused?
Yes,
Thank you.
thank you. Okay, Ms. Matter?
Good morning, Your Honor.
Good morning.
I am here on number 23 on your docket on behalf of Geico for a motion for substitute service.
CL 213806-I Geico County Mutual versus Jose Luis Lugo Jr. and Jose Luis Lugo.
Yes, Your Honor, and this is a request for substitute service on Jose Luis Lego, not on Junior.
Okay, so it's on Jose Luis Lugo. All right, go ahead.
We have made, our processor made 7 attempts. 2 of the attempts we spoke with, I believe, his wife, who said he was at work. So we do know he lives there, but they've just basically stopped answering the door now, and we're asking for the ability to leave notice at the home.
Okay. Your motion for substitute service is granted. Do you have an order on file?
Your Honor, you should have one there, yes.
Okay, I'll ask for that to be forwarded to my queue.
Perfect.
All right, anything else?
That is all I have for you, if I may be excused.
Yes, ma'am.
Thank you. Take care.
Likewise. Mr. Alamia, what do you have?
14, Judge. 14. 14. S 4774-21-9.
In the matter of the marriage of Juliana Cortez versus Eric Sanchez.
Yes, Your Honor, I'm asking to pass it because they're trying to reconcile, and I need at least 60 days.
Okay, let's go ahead, August the 29th, and I'm gonna just set it for a status. If it's ready for final, let us know. And it's status at 9:30.
Thank you, Your Honor, that's all I have.
Okay, you may be excused. Okay, Mr. Garcia, Attorney Rick Garcia.
Yes, hello?
Mr. Rick Garcia, you're on mute.
Sorry, Judge, I'm on number 17 on the docket.
Okay. CL 195934-I Maria G. Rico et al. Versus Jolyn Almanza.
Yes, Judge, we're here on we obtained a default judgment on the 12th of January, and we're here to go ahead and prove up the unliquidated damages, Judge, so that we can finalize this default judgment. And I'm prepared to put on evidence as far as the damages and the incurred.
Okay. And do you have your client here, or how are you going to prove it up?
I was just going to ask you, Judge, to go ahead and put me under oath, and I would go ahead and prove up the damages in terms of the medical bills and costs that they incurred in relation to this accident.
Okay, go ahead. You can raise your right hand. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth?
I do, Judge.
All right, you may lower your hand. Go ahead, Mr. Garcia.
Thank you, Judge. In terms of Miss Esperanza Estrada, Judge, she incurred medical bills with KIT Chiropractic, Rio Grande Regional Hospital, the Insight Diagnostic Imaging Center, in the amount of $13,247. With regards to Maria Rico, again, with KIT Chiropractic, Insight Diagnostic, Hidalgo County EMS, and the Rio Grande Regional Emergency Physicians, she incurred medical bills in the amount of $14,624.50. And finally, we have Daniel Rico, who was also in the vehicle, and he incurred medicals with the same entities in the amount of $13,392. We were asking, Judge, at this time that the plaintiffs be awarded each the sum of $75,000 regarding the injuries and the damages they incurred in terms of care and treatment and medical bills. Each suffered injuries to their neck, back, and shoulders. We've submitted an order on behalf of the plaintiffs asking for the final unliquidated damages to be awarded in the amount of $75,000 to each of the plaintiffs.
Okay.
That's all
Anything
I-
else?
Nothing else, Your Honor.
Okay. The court is taking judicial notice of the documents in the court's file, specifically the default judgment that was signed by the previous court and is granting the relief as requested on the record. Do
Thank
you have
you.
an order to that effect?
Yes, it's already been submitted, Judge.
Okay, I'll go ahead and ask for that to be forwarded to our queue.
Thank you, Your Honor. May I be excused?
Yes, sir. Thank you.
Thank you.
Okay, Mr. Garza, Attorney Rogelio Garza, what do you have, sir?
Good morning, Your Honor.
morning.
All the parties are ready for a friendly suit hearing?
All right. CL 21-4093-I, Mónica Rodriguez versus Eduardo Delgado.
Correct, Your Honor.
Good morning, Judge Rogelio Garcia for defendant Delgado.
Rogelio,
morning,
on
Your Honor.
behalf of the plaintiff. Sorry.
And I'm sorry, Your Honor, Dennis Ramirez on behalf of the court's ad litem in this case.
Okay. And Mr. Garza, you'll be proving it up with your client, Ms. Rodriguez?
That's correct, Your Honor.
Is she English speaking or Spanish speaking?
English.
Okay. Ms. Rodriguez, can I please have you raise your right hand?
Yes, ma'am.
And do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
All right. Can you please lower your hand? All right, Mr. Garza, go ahead.
Thank you, Your Honor. Please state your name for the record.
My name is Mónica Rodriguez.
You had 3 minor children that were involved in an accident on January 24th, 2021. Is that correct?
Correct.
And the 3 children are Alexa Montserrat Nunez, 14 years old, Ray Elias Nunez, 12 years old, and Rogelio Nunez, the 4th, who is 5 years old.
Yes.
You understand we're here today asking the court to approve a settlement offer that has been made by the defendant?
Yes.
Okay. And do you understand, first of all, on Alexa, they are offering $14,000 be paid on her claim, and out of that amount, that $4,239.31 be placed into the registry of the court.
Yes.
And as to Ray Elias Nunez, it's an offer of $3,000, and we're asking that $1,100 be placed into the registry of the court until he reaches the age of 18.
Yes.
Okay. And Rogelio Nunez, the 4th, $4,000 offer and $1,100 be placed into the registry of the court until he also reaches the age of 18.
Yes.
Do you understand these to be final settlements?
Yes.
We could have asked for a jury trial, but we're asking the court to approve the settlement offers.
Yes.
Are you asking the court to approve these offers?
Yes, I am.
Do you feel it's in the best interest of your children to?
I do.
Okay. And are you satisfied with my services as well as the services of Mr. Dennis Ramirez?
Yes.
I'll pass the witness, Your Honor.
Okay. Mr. Garcia, do you have any questions of Ms. Rodriguez?
Yes, Your Honor, just a few questions. Ms. Rodriguez, I understand that your children have fully recovered from the injuries that sustained in this car accident. Is that correct?
They have, yes.
And do you understand that the funds that are being deposited into the court's registry will remain in that registry in an interest-bearing account until your children reach the age of 18, or there is a court order allowing for early withdrawal? Do you understand that?
Yes, I do.
Okay, good. And as far as additional claims or funds pertaining to this particular accident, you signed a document, you executed a document on the 20th of May. Do you understand that by executing that settlement document, that absolves Mr. Delgado from any future claims, and that you nor your children will be able to request any additional funds for this particular accident and these injuries? Do you understand that?
Yes, I understand.
Okay, and as you were asked, you believe that this is a just and fair settlement?
Yes.
And it's in the best interest of your children to have Judge Ocaña Olivares approve this settlement?
Yes, please.
Are you asking Judge Ocaña Olivares to approve?
Yes, I am.
Your Honor, that's all I have. I'll pass the witness. Thank you, Judge.
Okay, Mr. Ramirez, do you have any questions?
Yes, sir, just briefly.
Go ahead.
Ma'am, just for the court's knowledge and information, you and I have discussed this case, and your oldest is now going to be an entering freshman next school year, correct?
Correct.
And then your middle son is going to be entering 7th grade.
Yes, sir.
And what grade will your youngest be going to?
He's graduating kindergarten tomorrow, so he'll be entering 1st grade.
Okay, and I thought that was the case. I wasn't sure it was today or tomorrow, so congratulations on that.
Thank you.
And once again, the children have healed, and you're ready to close this matter. And this was part of a bigger automobile accident that your husband was also involved in, and a settlement regarding him too as well, correct?
Correct.
No further questions, Your Honor.
Okay, so then, have you all already circulated an order to this effect with the instructions?
Yes, Your Honor.
We have, Your Honor.
Yes, Judge.
And
And for-
everyone signed off on it?
Yes, Your Honor.
Correct.
That will be filed as after Your Honorable Court approves settlement.
Okay. So this is not that, I mean, I'm going to approve the settlement, but this is my thought process. I mean, to me, $1,100 is very minimal to be putting in the court's registry, especially when you have 3 children that are going to be getting ready for the school year. So I don't have an issue with $1,100 being released to the 2nd child and the 3rd child, and then having $1,100 of the oldest child also being released to them and putting the rest in there. But honestly, at that point, it's minimal. So I don't even know if it's worth putting that 3,000 and change in there. So I don't know. Have y'all had an opportunity to discuss that, or would you all have issue if I just said, don't put any of this in the registry and just let them have the money now? Or I don't know, Mr. Ramirez, you can provide me with some guidance. To me, it's just too small of an amount to be in the registry, but that's just me.
And Your Honor, just for the record, as the court's ad litem, I have thoroughly reviewed the file, discussed this case with the plaintiff and all counsel of record, Your Honor, and I am asking the court to approve the settlement. I believe plaintiff's counsel did a good job in securing a recovery for his clients and working on reductions and his bill as well to make sure there was a maximum recovery for the 3 minor plaintiffs. Judge, with respect to that issue, I did visit with the mother this morning, and I did advise her that would be something that she could discuss with her counsel, in light of the fact that it was $1,100, and as we all know, her oldest entering 9th grade, the middle one going to 7th grade, and now 1st grader for the youngest. That money could certainly come in handy, and there is a need there, but I did leave it to the mom's discretion. And she said she would think about it and visit with her attorney, but I would not object to those 3 amounts being tendered to the mother on behalf of the minor children at this time.
Okay, and Mr. Garza, have you had an opportunity to discuss that with your client, or do you want me to? I don't have an issue with, the settlement at all. I'm approving it, but I'm just saying, do you have you had an opportunity? Go ahead.
Yes, Your Honor, we have discussed it, and we would like to have the funds paid to the mother, because as you mentioned, it's a minimal amount and they're of young age still, so it doesn't make sense to put all that money in for all those years with very little interest earned, of course, if any.
Correct.
Very little at least. Is that correct, Ms. Rodriguez? That's your understanding? It's okay with you?
Correct. And we recently, just 2 days ago, got a call from the STEM Health Science Academy that my oldest was accepted into, so they would really come in handy to get her prepared with computers and anything she might need. So
yes, because I'm very familiar with that program in the different school districts, and I do know that sometimes they, to assist them with the curriculum, they have to have certain things at home, and they're not provided by the school district, and so they would need to have certain things at home. So I don't know. So that's why I was thinking about that as the numbers were coming in. So if you can please assist the court and circulate the order again and have the language put in there that will be paid directly to the mother for the use and benefit of each child for the amounts that are netted for each child, please.
Your Honor, I understand it's the court's complete discretion and will oblige. I believe the checks have already been issued. If not mistaken, they have been received at Mr. Garza's office. So that would require, it'll require us to, or the carrier, to stop pay each of those checks. And I respectfully ask Mr. Garza to provide revised drafting instructions that will align with the court's order.
Luckily, I haven't cashed them yet, Your Honor, so I will return them.
Okay.
After I receive the revised instructions, I will then make the revisions in the final judgment and will recirculate to make certain that everyone is in agreement with it. And then we'll file after Mr. Ramirez has signed off on it and Mr. Garza has signed off on it. But I do respectfully ask that Mr. Garza provide those revised instructions as soon as possible. That way I can forward them to the carrier's adjuster so that can be dealt with.
I will provide them today, Your Honor.
Okay, and I think Ms. Rodriguez will, just so you understand, Ms. Rodriguez, you will have to wait a little bit to have those returned back to defense counsel and have those checks issued, but I don't think that's a problem considering that at the end result, you'll have them, you should have them in time before school starts.
No problem.
Okay, all right, then the court is taking judicial notice of all the documents in the court's file and approving the settlement agreement. And Mr. Ramirez, have your fees been settled on?
Yes, Judge, and that was included in the judgment, and I'm sure it'll be in the revised judgment as well.
Okay, and I do ask for all of you to please sign off on that revised judgment. And I wish you the best of luck, Ms. Rodriguez. Congratulations on your children's educational success.
Thank you so much.
Okay, anything else, gentlemen?
Nothing further. Thank you, Your Honor.
Defense, Your Honor.
Okay, thank you.
Thank you, Judge.
All right, y'all have a good day.
Thank you. You as well.
Bye-bye.
Thank you. Mr. Galvan, was it only that one case that you were on with Miguel Weiss?
It is, Your Honor. I didn't know if the
Okay.
court had already called it.
Yes, they were supposed to assist the court in contacting you, letting you know that it's set for status August 29th at 9:30.
August 29th at 9:30. Thank you, Your Honor. I appreciate it. You have a great day.
Likewise. Okay, Ms. Fuentes Aguilar, what do you have?
Good morning, Your Honor. I have number 2 on the civil docket.
Okay, F0299-22-9 in the matter of the marriage of Van Hugh HU versus Noon NGUN PUM PUM.
Yes, Your Honor. Give me 1 second. I'm gonna turn on my video. Judge, this is a divorce matter. Mr. Bravo is also on this case as the ad litem. We had to serve by publication.
Okay, Mr. Bravo, did you have an opportunity to review this case?
Yes, Your Honor, that is correct. I also met with Van who is the petitioner in this case.
Okay, so are we ready to proceed?
Yes, Your Honor.
Okay.
Yes, Your Honor.
And Mr. Hugh, if I can please have you raise your right hand? Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth? Okay, let me see. Go ahead, can you say that again?
Yes, I do.
Okay, thank you. You may lower your hand. Just go ahead and speak up because I can barely hear you. Go ahead.
Thank you, Your Honor. May I proceed?
Yes, ma'am.
Okay, Mr. Van Hugh, you are the person seeking a divorce in this action, is that correct?
Yes.
Okay, and you, Ms. Nguyen Phum was served by substitute service, correct?
Yes.
And you were married on or about April 16th, 2007, and you separated January 7th, 2012, correct?
Yes.
So you haven't seen her in over 10 years, is that correct?
Yes.
And there were no children born of the marriage, is that correct?
Yes.
And there is no community property to divide, is that correct?
Yes.
And as far as you're concerned, you just need a simple divorce, is that correct?
Yes.
And you're asking the court to approve it, correct?
Yes.
You've lived in the state of Texas for at least 6 months, in the county of Hidalgo for at least 90 days? And so you also, did he answer?
No, you didn't.
No, I didn't get a response.
Go ahead and
Okay.
ask the question again, Ms. Fuentes Aguilar.
Yes, Your Honor. Mr. Hugh, you've lived in the state of Texas for at least 6 months in the county of Hidalgo for at least 90 days?
Yes.
Okay, and you also are asking for a 30-day waiver of the, in order to remarry, correct?
Yes.
And there is no expectation of reconciliation. You haven't seen your wife in over 10 years, is that correct?
Yes.
Judge, I have nothing further. We would respectfully ask the court to approve this divorce, but also ask for the waiver of the 30-day period to remarry, Your Honor.
Okay, Mr. Bravo, any questions?
Just briefly, Your Honor.
Go ahead.
Mr. Hugh, did you, you and I had an opportunity to discuss your case?
I can hear, sorry.
Did you, you and I had discussed your case?
Yes.
And you haven't had any contact with her since 2012? And at that time, she was in Malaysia?
Yes.
And you haven't had any contact with her since then?
No.
And you don't have any contact information regarding any other family members?
No. No.
No further question.
Okay, the court is taking judicial notice of all the documents in the court's file. And I did grant the motion for substituted service and is granting the divorce as requested and testified to on the record. And Mr. Bravo, were your fees already taken care of?
Yes, Your Honor, they've already been.
Okay. All right, is there a divorce decree on file?
Not yet, Your Honor. I will file it before the end of the day, but will the court also approve Mr. Hughes' request to waive the 30-day period to remarry?
Yes, in consideration for the amount of time that considering the amount of time that he has not had any contact with his wife, the court is granting his waiver of the 30 days so that he can remarry sooner.
Thank you, Your Honor. I will file both orders by the end of the day.
Okay, I'll set a tickler for June the 10th, just in case.
Thank you, Your Honor. May we be excused?
Yes, you may.
Thanks.
Thank you, Your Honor.
Okay. Mr. Bravo, anything else?
Your Honor, I believe there was one other case with the Javier Flores, but I believe that an order had already been submitted.
Yes, sir.
But I'll follow up with that, Your Honor.
Okay, thank you.
Can I be excused? Thank you.
Yes. Okay, Ms. Rocio Youngs?
Good morning, Your Honor. We are here on number 8 on the civil docket, Judge. Attorney Yuri Rocio Youngs on behalf of my client, Delia Araujo. She is present on screen. Mr. Santos Maldonado is petitioner on this, Judge.
Okay, F2467-20-9 in the matter of the marriage of Alejandro Araujo, ARAUJO, versus Delia Araujo, ARAUJO. Okay.
And Judge, we are here on a final hearing, and I believe we are prepared to move forward with the prove-up, Judge.
Okay, Mr. Maldonado?
Yes, President Judge, for the petitioner, I believe we have everything worked out with the exception of maybe the drop off and pick up of the location for the boy.
Okay, how old is the child?
12.
Is your client requiring the services of an interpreter?
English or Spanish? I'm sorry, Judge, he does want an interpreter in Spanish.
Okay, that's fine. All right, so then we have a 12-year-old son and you all have not been able to agree where pickup and drop off is?
I'm not saying we're not able to agree. I think it's just a matter that we've talked about just recently, Judge.
Okay, what's the issue with pickup at the residence of the mother? Is there problems there?
Your Honor, just for the purpose of a healthy continued co-parenting relationship, my client just does not feel comfortable with pickup at her residence. She is inclined to any mutual location that Mr. Araujo would choose to elect. She just doesn't want it at her residence, Judge.
That's probably best, Judge. We had recommended Academy in Mission. I believe it's on Ware Road, because I think the mom lives in Stark County and my client lives in Hidalgo County.
Oh, okay. Where were you all thinking of, Ms. Rocio Youngs?
Your Honor, I have not had a moment to confer with my client on that location. And mainly because she's on Zoom as well right now, Judge, and she can't use her phone to discuss with me the mutual location. But again, I don't foresee that being a problem at all, Judge. I think that that could be definitely left between the attorneys after. I don't think that that's not a problem at all in this case, Judge. We just need to figure out a mutual place within the location from one party to the other, Judge.
Okay, and I understand that, but if I let you all off without getting that location, I'm gonna have a hearing in the next few weeks to decide the location.
And I
that's
understand
how
Judge.
that has happened in the past.
Of course, Your Honor. Let me ask
So-
Ms. Araujo directly. Ms. Araujo, would you be okay with the academy?
Right now, I do live in Port Lavaca. I don't live in Stark County.
And I
That's-
apologize, Ms. Araujo. What county is that? I don't know where Port Lavaca is.
Calhoun County.
Calhoun.
It's 3.5 hours from here, from the valley.
Given that information, Your Honor, I'm not sure if this case can be recalled, so counsel and I can have a moment just discuss this briefly, Your Honor.
Okay,
I can contact Mr. Maldonado immediately.
okay, yes, you can log off if you'd like, and then I'll recall it shortly, just to give you all an opportunity to do that.
I'll stay on,
Okay.
Judge, and I'll just contact Mr. Maldonado immediately. Thank you.
Okay,
Judge, excuse me,
Yes.
Judge, can I speak? Can you send us to a breakout room? Maybe all the parties can talk then?
that's fine.
I think that'd be better.
That would be great, Judge. Thank you so very much.
You should see an invitation on your screen, and you can join that breakout room. Okay, Mr. Holguin, what do you have?
Good morning, Judge. I have number 18 on your civil docket. I represent the condemning authorities.
Okay, CCD 0587-I, the state of Texas and Hidalgo County, Texas versus Jose Lauro del Bosque. And I believe the parties are in my office.
Yes, we are.
And Ms. Laguna is here as well. She represents one of the lien holders.
Yes, Your Honor, Gina Laguna for Novus Polaris.
Judge, so let me very briefly give you like some background on this case. So what's set for today is a motion for entry of final judgment. The time for objecting has long passed, right? So I'm just asking for a final judgment. There is one issue, and I'll just kind of summarize it. I can't advocate for the landowners, and obviously the lien holder has Ms. Laguna, so I'm not allowed to advocate for either party, but there was an award of $22,000 that was made, right? I deposited. Ms. Laguna filed a motion to withdraw the complete amount. She represents one of the lien holders. So Sierra Title issued a title report where 7 siblings are the joint owners, right? Now, there's an understanding between the siblings, nothing recorded that Ms. Marta del Bosque is she inherited this particular property is hers. The Sierra Title issued a report just based on her affidavit of heirship. So 7 siblings under Texas law, right? Both parents deceased, they co-own the property. Ms. Laguna's client has a lien on one of the siblings who has since filed a disclaimer of interest, right? So I think the issue you're confronted with here, and I'm not advocating for anybody, is the Novus Polaris, since the one sibling discount, do they get 0? Do they get his 1/7? Or do they get the entire 22? And I'm not advocating for anybody. I just leave it to your honorable discretion. I'm just asking for a final judgment, which we're entitled to, because no one's objected to the award and the time to object has passed.
Correct. Okay, go ahead. Ms. Laguna?
Yes, Your Honor. That was my understanding as well, that the property was inherited via an affidavit of heirship in 2013 to 7 individuals. No one filed a claim except for my client to the funds that were in the registry of the court. And under Texas law, if you inherit property, you can file a disclaimer, but it has to be done within 9 months that you inherit the property. I think Mr. DeBosque filed with this court some letter in Spanish purporting to disclaim the property, but there's nothing on file in the real property records. So we filed our application for release of the Special Commissioner's Award, and the court already granted it. And the clerk already sent the check to my client for the entire amount. So that's where we are right now.
Can I say something, Your Honor, please?
Yes, hold on. Everybody's gonna get a turn. And what is your name?
My name is Marta del Bosque, and I'm the owner of the property. And see, this is what happens. The first day that I met Mr. Holguin, he went to my house. We didn't have nothing. The property was still under my parents' name. They had not changed. I talked to Mr. Holguin. He told me what was going on, that they wanted 10 feet of the property. And I explained to him, not me knowing what was going on with this persons. I explained to Mr. Holguin, my parents gave this property to me when they were still alive. For whatever reasons you want, I took care of my parents, 7 years of my dad's sickness, and then 4 years of my mom's sickness. So all these years. They passed away, and I've been in and out of the hospital for many years. I'm disabled. Reason why they left this property to me is because we're 7, and I'm the only one that is disabled, and I'm the only one that has, I adopted 11 children. And I explained all this to Mr. Holguin. I have 4 special needs siblings that I adopted. They're adults, but they're like 6-year-old, mentally. And I didn't know this was going on at all. Mr. Holguin did not know that this was a problem on my brother's side. And when they changed the name, because he knew when they changed the name, all my siblings were very upset. And my sister from Monterrey went and talked to him in person and say, why did they do that? It doesn't belong to us. It belongs to my sister. But we didn't know then that this was happening to my brothers. On my brother's case. I don't know why they send the check to them, because the property is not my brother's. And Mr. Holguin cannot say that I'm wrong on this, because I told him from day one, and the property was still under my parents' name, that the property was mine. And I said, you can ask all my siblings, and they're gonna tell you that this is true.
Okay.
Judge, may I really quickly?
Yes, only because she kind of, I'm gonna allow you to explain.
Right, so
Go ahead.
she signed off on an affidavit of heirship, and Tierra Title, based on that affidavit of heirship, made a determination as to the ownership of the property. Now, if the sibling, I told her, if your siblings don't want any part of it, then they can just, not contest any of the money. I mean, you say the property's yours, your siblings can just sign off on the money for you. They can disclaim. And, we didn't go and change any deed or anything, right? On the property. It's just, she completed affidavit of heirship, which she signed off, and I gave it to the title company, and that's how they determined, right? And it's just the parents, both parents are deceased, and naturally it goes to the kids. So that's what happened. So that's the explanation, but go ahead, Judge.
I'm sorry, Judge, but Mr. Holguin, yes or no? You told me, nobody told me.
Okay, hold on. I'm not gonna allow that. First of all, I don't
Right.
even know why this was set via Zoom instead of in person, because obviously it's contested, but it's already here. Second of all, look, unfortunately, ma'am, there's a process to all of this, and you decided to also you decided to represent yourself pro se, and I understand your situation. And although I'm empathetic with what's happening with the situation, the issue is that your timelines or your deadlines have already passed. And so there was an award of this, and now it's just time to enter it. Everyone did what they were supposed to do because of the fact that there was no objection to the award, and nothing was done in a timely manner. And it unfortunately comes down to you just didn't know the process. But because you didn't know the process, these things do happen. And unfortunately, the only choice I have right now under the law is just to approve the motion for entry. And if you have any issues with that, then you would need to seek legal counsel to see what your possible remedy could be for that. In other words, how can you undo what's been done? But I can't undo it at this stage. So the only choice I have that I can do to follow the law is just to approve the motion for entry and sign off on that. And then after that, the rest is going to be up to you all.
Yes, and that was the problem, Judge, that nobody told me. I asked Mr. Holguin several times. They make it seem so easy because when he came to my house, he said, if you tell me that it's fine, I just write that check under your name and I put it on your. Nobody told me that the money was gonna be deposited in the court. Now, one of my brothers, my little one, he's been in the hospital for two months, and he had several strokes. He knows because I told him. And I didn't know I have to get a lawyer for this. I didn't know how many time I had. I came to this office and they didn't give me any help. I asked, nobody could help me.
Okay, hold on. It is not our job.
No, I know.
Unfortunately, we cannot give you any other help except to give you the date and time of this hearing. My staff nor myself are not allowed to give you any type of legal advice. Mr. Holguin's job is not to give you any legal advice. Ms. Laguna's job is not to give you any legal advice. It's very unfortunate the situation that you find yourself in, but there's not much that I can do at this point at all, except sign off on that motion for entry because the deadlines have already expired. So that is what I'm going to do. I'm going to ask for that order to be submitted to me. I'm going to sign off on it. Please make sure that you leave your email addresses with my staff, and you will get a copy of that email. And then from there, you'd have to decide what it is that you want to do. But this is not the proper time, nor do I know if it would be the proper venue to decide who gets 1/7 of what. So what I have to do is just follow the process. And unfortunately, I know that's not what you want to hear, but that's the situation that we're in at this point. So just leave your email addresses with my staff, and they'll make sure to get a copy of that sent out to you. Okay?
Yes, ma'am.
Okay. Thank you.
Thank you, Judge.
Okay, anything else?
Your Honor, may I be excused?
Yes. Okay, Mr. Palacios?
Good morning, Judge. Sonny Palacios here in number 12 on your civil docket. F470279.
Okay, in the matter of the marriage of Lee Garza Cuellar versus Ruben Cuellar.
Good morning, Judge. Sonny Palacios, Ms. Lisandra Garcia Cuellar. Judge, as you can recall, this is a case where this divorce was already proved up. However, there was an issue regarding consolidation of all the previous cases, which has been done and been signed by this court on May 3rd, 2022. Those cases were a case out of Bexar County, the child welfare case, and a protective order case. Each of the cases have already been consolidated into this case. The questions for proof have already been answered. What we can do, Judge, is Ms. Lisandra Garcia Cuellar is at the doctor's with her children right now. I'm sorry? But Mr. Cuellar is online. On this case, Judge, what we can do for economy, since the questions have already been answered, I can have the decree, the final decree typed up and signed by all parties to submit to the court if the court wishes.
Yes, that's fine.
Okay, we'll go ahead and do that, Judge. That would conclude our business for today.
Okay, you'll have until June the 10th to get that submitted.
We'll do so immediately, Judge. Thank you very much, Judge. You have a good day, Judge.
Thank you. Okay, Ms. Rocio Youngs, did you all get that worked out?
Yes, Your Honor, we have resolved all issues and ready to proceed.
Okay, Mr. Maldonado, have your client take his cap off. He's in a court of law. Okay, what, and you said that you needed the services of an interpreter, Mr. Maldonado, for your client?
Yes, Your Honor.
Okay, so I'm gonna recall F-2467-20-9. And Ms. Castañeda, please have Mr. Araujo raise his right hand.
Señor Araujo, por favor, levante su mano derecha.
Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth?
Jura que el testimonio que está a punto de dar es la verdad, toda la verdad y nada más que la verdad.
Sí.
Okay, tell him he can lower his hand.
¿Puede bajar su mano?
Okay, you may proceed.
Your name is Alejandro Araujo.
Sí.
Su nombre es Alejandro Araujo.
Sí.
Yes.
Your wife's name is Delia Araujo.
El nombre de su esposa es Delia Araujo.
Sí.
Yes.
You filed this divorce on July 21st, 2020.
Usted metió esta petición de divorcio el día 21 de julio 2020.
Sí.
Yes.
Before filing this divorce, you lived in this county and this state for more than 6 months. Is that right?
Antes de meter esta petición, usted vivía en este estado por más de 6 meses, ¿correcto?
Sí.
And
Yes.
in this county also more than 6 months?
Y en este condado por más de 6 meses, ¿correcto?
Sí.
Yes.
You have a son by the name of Alejandro Araujo Jr.
¿Tiene un hijo con el nombre de Alejandro Araujo Jr.?
Sí.
He was born on December 29, 2009.
Nació el 29 de diciembre del 2009.
Sí.
You filed
Yes.
this divorce because your marriage became insupportable because of discord and conflict of personality between you and your wife.
Y usted metió esta petición porque su matrimonio se ha vuelto insoportable y hay conflictos de personalidades, ¿correcto?
Sí.
Yes.
And because of this, it destroys the legitimate ends of your marriage relationship and prevents any reasonable expectation of reconciliation. Is that correct?
Y esto termina termina la relación y previene alguna expectativa de reconciliación, ¿correcto?
Sí.
Yes.
There was no other children born of this marriage. Is that right?
No hubo ningún otro niño nacido de este matrimonio, ¿correcto?
Sí.
You
Yes.
did not. Is it correct that you did not adopt any children?
Y es correcto que no adoptaron niños.
Sí.
Yes.
It's also correct that your wife is not pregnant at this time?
Y también es correcto que su esposa no está esperando bebé a este momento.
Sí.
Yes.
Now, you and your wife have entered into an agreement regarding the terms of a divorce in this case. Is that correct?
Y usted y su esposa han llegado a un acuerdo tocante este divorcio, ¿correcto?
Sí.
Yes.
Regarding your son, you and your wife have agreed that your wife is going to be the primary custodian or the managing conservator of your child. Is that correct?
Tocante su hijo, su esposa va a ser con la custodia primaria.
Sí.
Yes.
And you'll be a joint managing conservator having visitation for your child. Is that correct?
Y usted va a tener su conservador con general conjunta, ¿correcto? Con visitaciones.
Sí.
Yes.
Your wife presently lives in Port Lavaca, Texas. Is that correct?
Su esposa ahorita vive en Port Lavaca, Texas, ¿correcto?
Sí.
Yes.
And for that reason, there will be a geographic restriction of where your son could be. Is that correct?
Y por esa razón va a haber una restricción geográfica de donde vive su hijo, ¿correcto?
Sí.
Yes.
And that will be in Calhoun County, Willacy County, Cameron County, Hidalgo County, and Starr County. Is that correct?
Y eso va a ser en Calhoun County, Willacy County, Hidalgo County y Starr County, ¿correcto?
Sí.
Yes.
And as far as your exchange for pickup and drop off your son during visitation, you and your wife have agreed that that location will be at Whataburger in Raymondville, Texas. Is that correct?
Y tocante al intercambio, han llegado a un acuerdo que va a ser en el Whataburger que está en Raymondville, Texas, ¿correcto?
Sí.
Yes.
As far as child support, you and your wife have agreed that you will be paying child support in the amount of $309 beginning on May 1st, 2021.
Y tocante a la manutención de los niños, la cantidad va a ser 309 por mes comenzando en mayo 1º, ¿correcto?
Sí.
Yes.
And that will terminate when there are certain events that occurred that are listed in the divorce decree. Is that correct?
Y eso va a terminar cuando ocurran varios eventos que van a estar en el decreto, ¿correcto?
Sí.
Yes.
And as far as the division of real and personal property that you have from this marriage, you and your wife have agreed to those terms also. Is that correct?
Y también han llegado a un acuerdo tocante la división de sus propiedad y cosas personales, ¿correcto?
Sí.
Yes.
The residence that you and your wife had, that has been sold and the proceeds have already been divided for the terms that you and your wife agreed. Is that right?
Que la residencia de ustedes ya se vendió y los precios ya se dividieron, ¿correcto?
Sí.
Yes.
And as far as personal items that you and your wife obtained during the marriage, those items have also been divided. And she has what belongs to her and you have what belongs to you already. Is that right?
Y tocante a sus cosas personales que se acumularon también, esos ya se dividieron y ella tiene lo que le pertenece a ella y usted tiene lo que le pertenece a usted, ¿correcto?
Sí.
Yes.
You're asking the court to grant you a divorce?
¿Usted le está pidiendo a esta corte que le otorgue un divorcio?
Sí.
Yes.
Your Honor, that's all we have. We'll pass the witness.
Okay, Ms. Rocio Youngs, do you have any questions of this, of Mr. Maldonado's client? Ms. Rocio Youngs? Oh, she froze. Okay, I'm sorry, Mr. Maldonado, we're gonna have to see if she can get back on.
Okay.
And then, okay, Mr. Bettis, were you waiting for somebody or? I'm not
No,
sure.
Your Honor, I believe it's because my my Zoom application doesn't have the raise your hand. I've been trying to
Oh, I
react.
was wondering if you've been waiting for somebody to get on or something.
No, we actually just have a fairly quick announcement. Number 31 on your docket, Judge.
Okay, yeah, if it doesn't have it when you hit the reaction button, then that means that you need to do an update on your Zoom.
That's exactly what I'm going to do once I log off.
Okay, what number? I'm sorry?
31, Judge.
CL 164614-I, Rosalinda Signs versus Migdalia Raga et al.
Your Honor, Ivan Perez for the plaintiff, Rosalinda Signs.
Okay, and I do see that Mr. and Mrs. Melendres are on as well.
And Judge, I'm Jesus Salinas. I'm here on behalf of Amigos Para Siempre.
Okay.
And Judge, at this point in time, we're trying to work the case up for the mediation. I owe the defendant some disclosures, which I expect to get out within the next 2 weeks, essentially updating the medical records and billing records. And my understanding as well is that Amigos Para Siempre needs to take the depositions of the pro se defendants.
Okay, so how much time are y'all requesting to conclude that?
I guess about 60 days, Judge.
Sounds about right, Your Honor.
Okay, and then after that, you'd be ready to go to mediation then?
I believe so.
Okay, then let's do a status hearing on September the 12th at 9:30.
Okay, Judge, thank you. I have nothing further, if I can be excused.
Yes, Mr. Melendres and Ms. Raga, do y'all have anything to add? No? Okay. All right. So they'll be in touch with you to schedule that. Okay. Thank you. Then you're excused.
Thank you, Judge.
Okay, Ms. Rocio Youngs, it turned out you had frozen.
I know, Judge. I did get the end of it. I could hear, I just wasn't able to respond.
Oh, okay.
So I apologize, Judge, but I was able to hear all the way towards the end of the testimony from Mr. Araujo.
Okay. So do you have any questions for your client?
Just a few, Judge, very briefly.
Okay, go ahead.
Ms. Araujo, can you please state your full name for the record?
Delia Araujo.
And you are currently married to Alejandro Araujo, is that correct?
Yes, ma'am.
And you have lived in the state of Texas for a period of 6 months and Hidalgo County for a period of 9 months?
Yes, ma'am.
Thank you. Did you hear the testimony and the agreement put on record by Mr. Santos Maldonado?
Yes, I did.
Did you fully understand every part of that testimony?
Just the child support that I kind of didn't understand what he meant by other things in the degree.
Okay, so let me review that. Okay, so let me review that with you briefly. You and your husband have entered into an agreement with regards to a parenting plan for the children. Is that correct?
Yes, ma'am.
And as part of that parenting plan, you will be appointed joint managing conservators, with you being the primary conservator with the right to designate the primary residence. Do you understand that?
Yes, ma'am.
You understand that the child is subject to a geographic restriction of Cameron County, Hidalgo County, Willacy County, Stark County, and Calhoun County. Do you understand that?
Yes, ma'am.
Part of that is that Mr. Araujo will have standard possession of the child per the family code. Do you understand that?
Yes, ma'am.
Okay. Child support is to be set at $309 per the code. Do you understand that?
Yes, ma'am.
Okay. And child support will end accordingly when the child emancipates and or finishes high school. Do you understand that?
Yes. Yes, ma'am.
And without me putting words into Mr. Maldonado's and Mr. Araujo's testimony, that's what he meant by that at some point child support does terminate.
Yes, ma'am.
Now, both of you are responsible for medical and dental per the Texas Family Code. Do you understand that?
Yes.
Okay. And the child that was born of this marriage is Alejandro Araujo Jr., correct?
Yes, correct.
Mr. Maldonado asked if you are pregnant, and he meant specifically, if you are pregnant, are you pregnant with a child from Mr. Araujo?
No, I'm not pregnant.
Perfect, just to be clear. Thank you. Did you hear the testimony regarding the division of the community estate and the property?
Yes, I did.
And you are in agreement with that, correct?
Yes, correct.
Perfect. And you believe it's a just and right division of the community estate?
Yes.
Perfect. Are you asking this court to grant you a divorce and approve the agreements made by you and your spouse in the proposed final decree of divorce?
Yes, ma'am.
And are you satisfied with my services, Ms. Araujo?
Yes, very satisfied.
Thank you. No further questions, Judge.
Okay. Then the court is taking judicial notice of all the documents in the court's file, is granting the relief as testified to on the record. And how much time do y'all need to submit the final decree of divorce?
Your Honor, I believe my client, I'll be sending her for signature the decree right now. I would anticipate we can circle that back to Mr. Maldonado by end of day.
Okay, I'm gonna go ahead and just give y'all till June the 10th. I'm gonna set a tickler for that.
Yes, Your Honor.
Okay, anything else?
Nothing further from Ms. Araujo or myself, Judge.
Okay, then the divorce is granted. All right, best of luck to both of you.
Thank you,
Thank you, Your
Your
Honor.
Honor.
May we be excused?
Yes.
Thank you, Judge.
Okay, Ms. Huerta?
Good morning, Judge.
Good morning.
I'm here on the protective order case P0148-22-9. I'm sorry, Judge, I don't have a copy of the document.
Okay, it's number 29. Maria Torres versus Candelario Gaitan.
I believe the notes indicate he's in person at the courthouse.
Yes, Mr. Gaitan is there in person. Okay, Ms. Castañeda, can you please ask him who his attorney is?
Señor Gaitán, ¿quién es su abogado?
No tengo abogado.
I don't have an attorney.
Okay, I thought he had it. All right.
If I may, Your Honor, he
Go ahead.
does have an attorney for the criminal case. His attorney is Jorge Salinas for that case, Your Honor.
Oh, okay.
Oh, sí tengo a Jorge Salinas, pero él no está enterado de esta corte, ni yo estaba enterado de esta corte. Porque a mí
Okay, I
me
do have
me
Jorge
dejaron-
Salinas, but he was not aware of this court.
Well, okay, so on this protective order though, you are not asking for extraordinary relief of any kind of incarceration at this time, correct?
The state is not asking for incarceration, no, Your Honor.
Okay, so then he would need to hire somebody for this if he wants to do that. Just tell him, Ms. Castañeda, that this is not the type of case that would allow me to appoint somebody, so he needs to hire someone if he wants to.
Señor Gaitán, este tipo de caso no es que yo puedo apuntar a un abogado, o si necesita un abogado, usted necesita contratar uno.
Ok, es que yo no sabía de esta corte, apenas me dejaron ¿cómo se llama? Me lo dejaron el viernes. Y yo
Okay,
no
because I
sabía.
didn't know about this court. They barely gave it to me on Friday.
Okay, is he asking for an opportunity to hire an attorney?
¿Está usted pidiendo una oportunidad para ir a contratar un abogado?
Sí.
Yes.
Okay, so Ms. Huerta, would you just be requesting to extend it and allow him some time to get someone?
We can do that, Judge, and if he isn't able to retain counsel, he can also contact us directly, and we can talk to him about that. However, if he is going to retain counsel, we need to speak to that attorney, obviously. We have no objection to a 30-day reset and extension to allow him to get counsel and to reach out to us, Your Honor.
Okay, what phone number would he be able to contact you at?
It's 956-292-7613.
Okay, Ms. Castaneda, please let him know that I'm gonna give him an opportunity to obtain counsel. But if he doesn't find one, he can contact Ms. Huerta at 956-292-7613.
We would just ask for a reset and extension date to the next hearing date, Your Honor.
Yes, go ahead, Ms. Castaneda.
Señor Gaitán, le voy a dar una oportunidad de que contrate un abogado. Le voy a dar también el número de la señorita Huerta, que es 956-292-7613.
Okay, hold on. Tell him not to be talking over you and that you all will give him a note with it.
Ok, no esté hablando sobre mí y ahorita le damos una notita con el número. Ok.
Okay, and then we're gonna go ahead and set this. For June 27th at 1:30.
Yes, Judge. Do you want the applicant present as well, or should we have her on standby?
Well, if you're gonna finalize it at that time, then she needs to be present, but if we're just gonna extend it again, it's fine.
Okay.
Okay, and at this time, it'll be via Zoom unless you all are told otherwise. And you can submit that to my queue and we'll get it signed for you.
Yes, Judge.
Okay, Ms. Castañeda, please let them know that it's gonna be on June 27th at 1:30. At this time, it'll be via Zoom.
Ok, señor Gaitán, la próxima corte va a ser el 27 de junio a la 1:30 de la tarde y por ahorita va a ser por Zoom.
27 de junio a la 1 de la tarde.
A la 1:30, 27 de junio.
Ok.
Judge, I have no further business before this honorable court. May I be excused?
Yes,
Thank you. Have a good one.
thank you. Let him know that he's excused.
Señor Gaitán, ya se puede retirar.
Ok, gracias.
Thank you.
Okay. Let me see. Anyone else?
I'm still here, but I'm waiting for Fela. I don't know.
Yeah, she's still hopping in between courts.
Yes,
Okay.
I'm here too. I was the number 5 and they skipped my number.
No, we just go in the order that I see the raise your hand. So since you're there in person, it's towards the end. So then it's F0597-22-9 in the matter of the marriage of Nancy Garcia and Enrique Garcia. Was Mr. Enrique Garcia going to be present?
No, he's not.
Okay, one moment. Okay, so you and your husband do not have any children together
No, ma'am.
and no community property?
No.
Okay. All right, please raise your right hand. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, it's gonna be.
Okay, you may lower your hand. Just speak up a little bit. Can you please state your name for the record?
Nancy Garcia.
And you're currently married to Enrique Garcia Jr.?
Yes.
And at the time that you filed for a divorce, you were a resident of Hidalgo County for at least 90 days and a resident of Texas for at least 6 months?
Yes, ma'am.
And you are asking for a divorce today because your marriage has become insupportable due to discord or conflict of personalities that has destroyed the legitimate ends of the marriage?
Yes, ma'am.
Okay. And is there any chance of reconciliation?
No, ma'am.
And you all were married on or about April 17, 2014 and stopped living together on September 30th, 2019. Is that correct?
Yes, ma'am.
And there is no child born or expected of this marriage. Is that correct?
Correct.
And you and your husband have acquired no community property together. Is that correct?
Correct.
So the vehicle that you own, the 2021 GMC Canyon, and the vehicle that he owns, a 2020 Lexus, that was purchased after the separation?
Yes.
Okay, and those are under each of your names?
Yes.
Okay, and you're asking for a name change to Nancy Rangel?
Yes.
Okay. Are you keeping your middle name or just the middle initial?
I just want the I just want to keep Nancy Rangel. I don't want
Oh.
the middle initial.
Okay. All right. So the court is taking judicial notice of all the documents in the court's file, specifically the waiver of service that was filed by the respondent on February the 17th, 2022, wherein he does state that the court can take this up without further notice to him. And he also has proffered his own testimony in that waiver. The court is granting the divorce as requested and testified to on the record. I will sign the divorce decree that was e-filed today. I'll ask for that one to be forwarded to my queue.
Sorry, can I get a translator for that information?
Well, you already spoke in English, so that's my understanding that you understand English.
Yes, I understand, but I want to be sure because that is not my first language.
Okay, so what is it that you weren't understanding, so I can have Ms. Castañeda translate that?
The last information, the December 2022.
Oh, okay. So just let her know, Ms. Castañeda, that I'm taking judicial notice, which means that I'm accepting the waiver that he filed on February 17th, 2022.
Nada más que la corte está aceptando los documentos que usted metió con la corte, que es el waiver que metió el 17 de febrero del 2022.
Okay.
Okay.
And that in that he also stated exactly what she said on the record. So
I'm sorry.
Go ahead. No, go ahead.
Y en ese documento él dijo lo que usted acaba de poner en testimonio.
Okay. So do you understand?
Yes.
Yeah.
Sí.
Yes.
Okay. All right. So then once that, do we have your email address, Ms. Garcia, or now Ms. Rangel, on that divorce decree? Let me check real quick. Oh, no, I only have an address. May I have an email address for you, ma'am?
Yes, it's Nancy Garcia R87@gmail.com.
Okay, that way we can email you the divorce decree once it's signed.
Okay, you're gonna send it by email the signed decree.
Yes, ma'am. Yes, ma'am.
Okay.
Okay, so if nothing further, you are divorced, and as soon as you get that decree, you'll be able to change your name.
Okay, with that paperwork, right?
Yes.
And that I still need to keep the information that I send this paperwork.
Oh, no, once you get your divorce decree, the only thing that you'll need is that divorce decree.
Okay.
Okay?
Mm-hmm.
All right, anything else?
Do you know like when I'm gonna have that paperwork, like month and?
Oh, no, probably by tomorrow or Friday.
Oh, okay, perfect. Okay.
Yes. Okay.
Thank you. Did I end all the calls?
Yes, you may just step away and I'm gonna mute it. Someone else is gonna use it after you.
Okay, perfect.
All right, thank you. Okay, Ms. Olivares, is that you?
Hello, Judge.
Yes,
Your Honor, it's me.
Oh, okay, good. Okay, sorry about that. All right, let me call
not a problem, Your Honor.
F 3494-21-9 in the matter of the marriage of Sharon Herrera and Raul Hernandez.
Your Honor, fellow Olivares for Sharon Hernandez, and she should be at the office. I just checked with my office. She was still there.
Okay, nobody is logged on, but I believe Mr. Hernandez. Raul, is that you?
Yes, ma'am, that's me.
Okay.
They should have logged on, Your Honor.
I don't have anybody except for Mr. Hernandez, Veronica Delgado, and somebody on a TCL 9048S.
Okay, Veronica Delgado is also mine, Judge. Can we move to that one? And let me just text my office to get her back on.
Sure. And is that on the interest of a minor child?
For this one or for Veronica?
No, for Ms. Delgado.
Ms. Delgado, yes. It's in the interest of
Okay.
Eileen Lynette Montes.
All right, F-3588-14-9, it's number 11 on the docket. Go ahead, what is the announcement?
Judge, this one was a petition to modify possession and also for arrears. It's a petition for motion for enforcement and a modification. Judge, Ms. Delgado is on and she sent me the arrears on this case this morning. Attorney General was involved, but they left the case, they non-suited it. There is, and let me look, and what I did, I had her send the arrears for child support to the office so they could do a trial exhibit, and they did file the trial exhibit. Let me tell the court how much it is. Let me see. And the other one on the modification was going to be the access and possession, and we actually have a temporary order that we were following. Let me see.
Okay, so for the modification of the possession, you're gonna stay with the temporary order at this time.
Well, I'm going to look at it, Judge, in just a minute and make sure that we didn't change it because we had Catherine Alvarado as the attorney ad litem. Is she back on?
Well, she thought that you were only taking up, her announcement was that she thought you were only taking up child support. She did, is this supposed to be to finalize everything?
I think we can do it, Judge. Ms. Delgado, we've been waiting for some time, not for this court, but we were in County Court 8 back then. The balance of the unpaid arrears, Judge, and for child support is $31,007.80. And that is because Veronica sent me, if the court, I don't know if you're able to see that the trial exhibit, Judge, probably not because it was just e-filed, but according to the financial activity report, it is for February, getting Zoom calls, February 23rd, 2022. And that's against Juan Manuel Montes. He was in jail for some time for assault on my client, Veronica Delgado. And I don't know if he's out of jail, if we can call his name. The last time we came before you, Judge, we did send out notices. I don't recall the date here off my.
What is the respondent's name?
His name is Juan Manuel Montes.
Okay, so Juan Manuel Montes, for today's hearing, was he notified via email, how would he have been notified?
To the last known address of 3907 J&A Drive, Mission, Texas.
Okay.
And he didn't appear for the last two hearings, Judge, either.
Right, okay. And so we don't know, so do you think he's incarcerated or?
I don't know, Judge. Maybe my client might know. I'll ask him. I'll ask her. But Judge, we had a temporary orders with no visitations. Judge,
correct.
Yes, Judge from County Court 8, Maldonado, stopped the visitations because of family violence. And Ms. Catherine Alvarado had also agreed to that. No visitations because he's a violent person.
Okay.
So we want to remain the same, Judge, for sole managing conservator, and I can ask her the questions, and that way the court can approve it or ask us if you need more information from us. But our pleadings are asking for sole managing conservator because of family violence.
Okay, so my staff already contacted Miss Alvarado to get on, so she should be getting on shortly.
Oh, okay.
For that.
Let me see if.
Okay, she's on.
Sharon got on.
Hold on.
Okay, all right.
Yes, and your other client is already on. Okay, Miss Alvarado, can you hear me?
Yes, Judge.
Okay, so we're on that F-39, I'm sorry, F-3494 dash, no, we're not. F-3588-14-9, in the interest of the minor child. Ms. Olivares is letting me know that it is ready for final. That's why we asked for you to come back on.
Okay.
And so Ms. Olivares is she did get the information with respect to the arrears. And so now she's ready to proceed. Ms. Olivares, did I understand correctly that you're asking for the temporary orders to become final?
Yes, Your Honor, these would be the modified temporary orders that are dated June 26, 2019 and signed by Judge Maldonado on June 28, 2019. In here, the visitations were changed to possession and access shall be modified to no visitations due to domestic violence. And they were stopped back in June 26, 2019, pursuant to the attorney ad litem, Ms. Catarina Alvarado recommendation. Actually, it was Ms. Alvarado's recommendation to the court because of the family violence.
Okay, so.
Is that correct, Ms.
Yes, Judge, and just to clarify the record, the family violence was not against the child or Ms. Delgado. It was against the respondent's new partner, and because of that, he was arrested. He also had a violent criminal history for the court's information.
Yes.
Because of that, he was, I believe, his parole was revoked, and he was sent back to prison. And he had new domestic violence charges, and he just has a history of domestic violence and violent cases. And I believe one of them was against the mom in this case, Ms. Olivares's client. So I believe it's in the best interest that he just not have any access to the child based on those circumstances.
Okay, so then you're fine. You're okay with the case moving forward with final then?
Yes, Judge.
Okay, all right. So Ms. Delgado, can I please have you raise your right hand? Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can turn your video off. It's fine. Go ahead, Ms. Olivares.
Yes, Your Honor. Ms. Veronica Delgado, can you hear me?
Yes, I can.
Oh, okay. Ms. Delgado, we filed a petition to modify and also a motion for enforcement back in July 10th, 2018. Is that correct?
Yes, ma'am.
And you were asking the court in those pleadings for you to be named sole managing conservator of the child, Eileen Lynette Montes, because of family violence, and is that correct?
Yes, ma'am.
And for the record, you were granted a protective order signed back in April 1st, 2014, which was in effect all the way to 2016 because of family violence against you by respondent Juan Manuel Montes. Is that correct?
Yes, ma'am.
And based on this and the conversations that you, the attorney ad litem, Ms. Alvarado, myself, and the court, and our pleadings, you're asking the court to appoint you as sole managing conservator of your child, Eileen. Is that correct?
Yes, ma'am.
And also, we will adopt the last modified temporary orders as to visitations that were recommended by attorney ad litem, Ms. Alvarado, based on what she testified what she proffered to the court a few minutes ago. And you're asking the court to remain the same as no visitations with the child until he comes and modifies before this court. Is that correct?
Yes, ma'am.
Okay. Now, I know that you wanted an increase in child support, but we neither have, we don't have any evidence as to how much he earns. However, we do have evidence in the last time regarding health insurance, and you're asking the court to increase the $57 to $118 per month because the Attorney General has suggested that amount, but now since has non-suited their case. But it's in the best interest that he pay $118 per month for health insurance. Is that correct?
Yes, ma'am.
And back to the child support, we, at this point, since you don't have evidence of where he works or if he works at all, we're asking the court just to remain the same, the way the Attorney General had it before filing this modification. Is that correct?
Yes.
And your arrears, we read them into the record already, was a 31,007.80 as of May 23rd, 2022. And you're asking the court to grant you a judgment on said amount payable to you from Juan Manuel Montes. And based on that, we don't know his income, that he pay $100 per month, which barely is going to cover the interest on that 31,007.80. Are you in agreement with that?
Yes.
Okay. Is there anything else that I didn't bring to the court's attention or ask you for the court to approve?
No, that's it.
Okay. And you're asking the court to approve this request that you have before this court. Is that correct?
Yes. Yes, correct.
Okay, I'll pass the witness, Your Honor.
Okay, Ms. Alvarado, do you have any questions of Ms. Delgado?
No, Your Honor, I don't.
Okay, and have your fees already been paid?
Yes, Judge.
Okay. All right, then the court is taking judicial notice of all the documents in the court's file, granting the relief as requested and testified to on the record by Ms. Delgado. And I'll wait for an order to that effect to be e-filed by June the 10th, please.
So June the 10th, Your Honor?
Yes.
Thank you. Yes, I will do that, Your Honor. Thank you so much.
Okay, anything else?
Not on this case, Your Honor.
Okay, Ms. Alvarado, anything else?
No, Your Honor.
Okay, all right, then you are excused, and Ms. Delgado, you are also excused.
Thank you.
Judge.
Okay, so let me recall F 3494-21-9 in the matter of the marriage of Sharon Herrera and Raul Hernandez. Ms. Herrera is present in your office, Ms. Olivares. And
Yes,
Mr. Hernandez, will you be representing yourself today?
Yes, ma'am.
Okay, Ms. Olivares, go ahead.
Yes, Miss Sharon, can you hear me?
Okay, you're on mute, ma'am. You'll need to have somebody come and unmute the computer for you.
Did they unmute her, Your Honor?
They have not unmuted her yet.
Okay, let me text them.
Oh, they're coming.
Okay.
Yes, Ms. Olivares, I can hear you.
Okay. Miss Herrera, would you please state your full name for the record?
Sharon Herrera.
And Mr., you're aware that Mr. Raul Hernandez, respondent, is on Zoom present for this final divorce hearing. Can you see him?
Yes.
Okay. And the last time we had a hearing before this honorable court was on September 22nd, 2021, which he did not appear, and consequently we have temporary orders that the court approved because of his non-appearance. Do you recall that?
Yes.
Ooh, I'm having problems with my phone, I think.
No, it's not you. It's somebody else. I just muted them. Go ahead.
Okay. Is that correct, Sharon?
Yes.
Okay. And back then, in regards to, you have been appointed joint managing conservator of the children. You'll be the primary. You're requesting this honorable court to continue the temporary orders for you to be the primary conservator of the children and joint managing with equal rights, duties, and responsibilities by Mr. Raul Hernandez. Is that correct?
Correct.
Okay. Now, in reference to the child support, the court had approved beginning October 1st, 2021, 1,023.92. And I apologize to you. I didn't ask you before, but did he ever start paying this amount of money that the court had approved for your child support?
He did.
Yes or no?
He did.
Okay. Does he owe you, from that year up to now, does he owe you any back pay, months, arrears?
No.
Okay. So beginning then June 1st, has he paid you May 2022?
Yes, he has.
Okay, so beginning June 1st, 2022, you're asking the court to continue the child support at 1,023.92. Is that correct?
Correct.
Now, in regards to the visitations, they were limited because your children are tender years children. Heaven Grace Hernandez was born February 2015, so that makes her 7 years old. Is that correct?
Correct.
And Faith Hernandez was born October 26, 2018, so she's 3 years old. Is that correct?
Correct.
Okay, and based on that, the temporary orders were that he was to pick up the children every Saturday from 10 a.m. to 6 p.m. and every Sunday from 10 a.m. to 5 p.m. And he was to drop off the children on Sunday at 5 p.m. so that the children could attend church services with you. Is that correct?
Correct.
Now, do you, well, before I ask you that question, we still have a child under 3, which is Faith. Are you asking this court to continue with that possession until the child turns 3, and then the child can go the old standard first, third, and fifth weekend from Friday at 6 to Sunday at 6, and every second and fourth weekend from 6 to 8 for visitations for the father for your children, both of them?
No,
I'm sorry. Did I confuse
can you
Let me
please
take one at a time.
repeat that? Because that was even
Yes.
confusing for me.
Yes, I'm sorry. It was too long and ambiguous. Here we go. Let's do Faith first. Faith is your younger child, so you're asking the court to continue this visitation. Is that correct? The possession, the one we had in the temporary orders.
Correct. She's already 3. She turned 3 in October.
Yes.
Yes.
Oh, she turned 3. Oh, that's right. I'm sorry. She'll be
Yeah,
4
so
then.
she should already
Okay.
be.
Okay, let me re-ask you. All right, then now that your last child is over 3 years old, you don't have a problem with Mr. Raul Hernandez to continue to go to the old standard possession because of the child being young still, which is the first, third, and fifth weekend beginning Friday at 6 to Sunday at 6. Is that what you're asking the court?
Correct.
And then when the second and fourth weekend, when Mr. Hernandez you have the children, then he can see the children during the school year on Thursday, 6 to 8. Are you okay with that?
Can you repeat that again? I'm so sorry.
It should be
Yes,
every
Thursday.
Thursday. I'm sorry, it should be
And now
every
even
Thursday
if
during the school year.
Right, every Thursday during the school year, 6 to 8.
Correct.
Are you asking the court that? Okay. Now, let me ask you this so the court will know why we tailored the visitations so limited at the beginning. Isn't it correct, Ms. Herrera, that you filed this divorce with a restraining order because he had your children and he said he was not going to return your children? Back then, I'm talking about when we filed. Is that correct?
Correct.
And now at this point, as time has passed, both you and him have been able to work out visitations with this order. But now, do you trust him that he will return your children after each visitation?
Correct.
Okay. are you asking, well, let me go and prove up the divorce. At the time that we filed, Ms. Herrera, you lived in the state of Texas for 6 months and 90 days in the county, is that correct?
Correct.
Okay, let me get yours. And without me going, because of the circumstances where I find myself here, would you state that day that you were married on the record?
Yes.
Here, I found it.
July 23rd, 2014.
And you were separated on July 14th, 2021, is that correct?
Yes.
And at that time, you had filed your grounds for divorce of insupportability, one of them, and conflict of personalities. Is that correct?
Correct.
And you had also filed the grounds of guilty of cruel treatment towards you and extremely verbally abusive towards you. Is that correct?
That is correct.
However, hold on, before you move on, are you asking for that to be grounds or are you just gonna do insupportability?
Judge, we're gonna do insupportability because they have, but I wanted the court why we went to that extreme at the beginning. Now that the time has passed and they have talked and they get along better, to answer the court's question, we're going with insupportability.
Okay, as long as it's that insupportability. Okay, go on.
Yes, yes. And Ms. Sharon, back to, do you want, you never used his last name, did you, Ms. Sharon?
No, I did not.
Hernandez. Okay. And you understand, are you working?
Yes, I am.
Okay. You understand that at the beginning we did put spousal maintenance there, but now you are back working and you're not asking this court to give you any, it's called spousal maintenance, the legal term, but to understand, everyone's understanding it's alimony. You're not asking for that anymore, are you?
Correct.
Okay. Are you still wanting the court to continue the restraining order regarding yourself, like for example, not calling you with vulgar language or harassing phone calls? Do you still want those 4 bodily restrictions for you at this time?
Not at this time.
Okay. All right. Just checking with you to make sure that we get everything we need to ask the court. All right. And you are asking for a divorce?
Yes, I am.
Okay. Now, at the property that you all had, it wasn't, both of you were running a business named Taqueria Cielo in West Lacombe. Are you asking the court to give you, to grant you 50% of that business? Or what do you want the court to what are you asking the court regarding this business?
Correct. I just want my
50%?
part. Correct.
Okay. And in dollars, what would that part be? So the court can have an idea and we can put something on the record. Or is there, or do you want us to do like are you asking for to do like a business evaluation or on it and then just ask the court for 50% of what the value of the business is?
Or are there corporate tax returns? Are there something that you would be able to base?
It's a little part. No, Judge, it's a little business that is not actually, I don't know if Mr. Hernandez might have incorporated. We better ask him as soon as we finish this. Ms. Herrera, another question regarding your stimulus checks. Did you ever get your children's checks back from him? It was $1,800.
He paid it off. Yes, he gave me the money.
Okay, you got it.
A couple of months ago, he gave me $2,000 regarding that.
Okay. So is that matter settled and you're not asking anything on that part right now? Is that
Correct.
Okay, let's go back to the business. The business on 1015 Taqueria Cielo, you both of you during the marriage purchased the land and built the business that is there, the building. Is that correct?
That is correct.
And that's what you're asking the court to award you 50% of whatever the value of the land and the building and the business is. Is that correct?
That is correct.
Okay. I know you wanted to say something. I'm sorry, I cut you off. Did I forget something in reference to the stimulus?
No, regarding the stimulus, he, like I said, he gave me money. At that time, he hadn't, but he would give me monthly. But regarding my tax return, he filed the girls, and I was just I had already filed. Well, he filed them first. I was already in the process of getting them filed. And regarding that,
all right, hold on. Let me ask you the question, Ms. Herrera. Okay, you, Mr. Hernandez took your deductions from the children for last year without your consent. Is that correct?
Correct. He had told me.
And
correct.
Hold on. And you're asking the court that whatever he got awarded, that he gave you 50% of that return, that income that he reimbursement.
The thing is, I had already filed my girls. He filed them first, and well, now I'm in the my case is still pending because of that. Because he put the girls.
That's why you're asking that's why you're asking the court that with whatever he got, because he used the girls, we'll ask him in a few minutes, is that you get 50% because he took your deductions, your exemptions for the girls for last year. Is that what you were requesting the court?
Correct.
All right. And even though your return is pending, but it's pending because of that issue that you claimed them and he claimed them first.
Correct.
What was the date of separation?
July 14, the same day, July 14, Your Honor. I closed my
2020 or 2021?
2021.
And the income tax that's in question is what years?
2021.
Okay.
Is that correct, Sharon? 2021?
Correct.
Okay. All right. Oh, and they're still married up to now too, Judge. Okay, did we, and each of you to get your vehicle, you're okay with that, Ms. Herrera?
Correct.
Is there anything else that I failed to ask you and you want me to address the court?
That is all.
Okay. I'll pass the witness, Your Honor. Oh, I'm sorry. And you're asking for a divorce?
Yes.
And before I let you go, I need to ask you these personal questions. At this time, are you expecting a child?
I'm so sorry, I didn't get that. Can you repeat it once again?
Yes. At this time, you're not expecting a child. Is that correct?
Correct, I'm not.
And you and your husband did not adopt any children?
No, we did not.
And you're asking the court to approve this in the best interest of your children?
Yes.
Your request. And you believe that this is just and right?
Yes, I do.
Division. Thank you. I'll pass the witness, Your Honor.
Okay, what questions do you have of Mr. Hernandez? Or Mr. Hernandez, you heard everything that Ms. Herrera said. Are you in agreement with all that, or what is your position?
How you doing, Your Honor? Ma'am, first of all, I wasn't aware of the second meeting. I believe I never got an email in reference to that meeting. I believe Sharon advised me of a meeting canceled. She never got back to me. She never told me that there was another meeting. And that's why I didn't attend. I'm a man of my word, and I like attending to these meetings. And also,
But
Yes.
as far as what Ms. Herrera has testified to, are you in agreement with all of
Well,
that? Or what
There's a
is?
lot of questions that haven't been answered, you know, like in reference to the property. Also in reference to that, for the divorce mediation, we haven't discussed about like the dividing of the assets, determining the custody of the kids, none of that. And, you know, and I believe that was the second meeting, but I didn't attend because I wasn't aware.
Okay, and are you going to obtain counsel?
Counsel, like, okay, can you
Are you
explain
going
that?
to get an attorney?
No, ma'am. I cannot get an attorney, and the reason is because we have a business and we're in debt. The taqueria the restaurant I currently owed $61,000. And
Okay, so that's the thing too, is that you're saying that she wants part of that 50% of the business and she needs to incur 50% of the debt as well.
of
And
course.
so
so-
hold on, I'm talking to Ms. Olivares. The other issue that you're gonna have is with respect to the IRS. I'm not gonna make a decision on that because the IRS says that the children only have to be with the filing party for at least 6 months. And though they didn't divorce until 7 months into the year. So technically either party would have had an opportunity to actually file for those children. It sounds to me that, you know, I understand, Ms. Olivares, that you want to get that done, but it doesn't sound like Mr. Hernandez is in agreement with not that he's not in agreement with everything. He has some questions with respect. So either he's not going to be getting an attorney, so you'll have to deal with him pro se. I would need to see you all in person, and in order to do that, it would be June 15th at 1:30. If you want to attend mediation, Mr. Hernandez, then you would need to do so before then, and you need to contact Ms. Olivares in order to get that done.
And Judge, with all your respect,
Judge, and just for, go ahead,
Yes,
Mr.
I've been trying to go to mediation. I've been trying to talk about all of this with my wife and her lawyer. There's never been like an appointment or something like that. I've called Miss Fela multiple times and I haven't left messages and I haven't received nothing from her. And
Judge, I don't like, if I can cut you short because it's 12:30 and the judge has been working all morning and I have to get back to another court. Mr. Hernandez, Sharon told you and I told you that we had temporary orders. We reset them and twice, Your Honor, he did not show up. So he can't come and tell you that he didn't know. He knew. And Sharon is under, that's why, hold on, that's why he pays the child support because he knew. And we send him copies of the default temporary orders. Now, I'm not going to negotiate a case with him. I can tell him what we want, and what he doesn't agree, then we bring those issues to the court. I can do it through a letter, but I'm not going to sit down with him and be his lawyer and negotiate, and then he calls it a conflict. And I wouldn't like to go to mediation and spend his time, his money, he doesn't have any, and Sharon doesn't either, and try to mediate with someone that doesn't have an attorney over on the other side, Judge. I don't think that's fruitful. But I'll be glad to come back in June 16th, and he can show the court whatever he wants to show the court, and I'll do the same thing we did today.
Okay, but the thing is that I'm not going to mediate this case either. And so you all need, you know, I'll make decisions once you all can't agree to things, but I can't sit there and be the mediator as well. So what I'm going to do is, I mean, both parties have a right to either represent themselves or have counsel. And this court requires mediation prior to a contested hearing. So what I'm going to do is I'm going to send over an order of referral to mediation. You all need to mediate that within the next 2 weeks.
Judge, I'm going to be out of town. Hopefully, it's June the 9th through the 16th to come work. Yeah, through the 14th. No, it's the 14th.
Then we're gonna come
Judge,
back. No, we're gonna come back on June the 29th at 1:30.
Okay.
And mediation, you'll receive an order to mediate very soon,
Judge,
this afternoon.
Can it be somebody like that doesn't cost so much? like Edna, because they don't have any money. So either one, both of them have to come up with $500, even for Edna.
Yeah.
And if we get somebody else that is expensive, well, they're not gonna be able to do it, and then
Well,
probably waste.
I'm going to order you all to mediate with Evelia. Evelia is reasonable.
I think she said 552
Well,
Judge,
at this point, and
yes.
yes, ma'am. Ma'am, and that's why it's important for me to talk to Sharon and to get to the bottom of this. The taqueria, my dad owns also part of the taqueria.
Okay, I'm not gonna take anything up with any of those facts with the case right now. You all need to go to mediation, talk about it there, and then whatever's not agreed to at the time, then I'll go ahead and take it up. Okay, but I don't want to hear any more facts.
Yeah, because
Judge, and
that's mine.
Your Honor, and I ask that he not speak to Sharon. Sharon has gone through a lot with him, so please, he needs to. If he wants to talk to me, I will talk to him, but he can call me.
Okay,
Wednesday or
I'm not
Thursday
gonna order
in the
him
afternoon.
not to, look, I'm not gonna order him not to speak to Ms. Herrera because she has they have to deal with each other with respect to the kids. Now, it's like, if he starts yelling at her, if he starts being vulgar or anything like that, well, of course, Ms. Herrera doesn't have to speak to him. But they should be able to be adult enough to discuss some of these issues. But if they can't, he doesn't have to, Ms. Herrera does not have to discuss the legal side of it with him. But with respect to the
Your
children,
Honor, with all due respect to you, Mr. Hernandez is a very forceful and strong man with words.
Okay, I'm not gonna, hold on. Ms. Olivares, right now I'm not gonna be going, because then it's gonna go to a back and forth where I'm sure he has things to say about Ms. Herrera too. It's not always a one-way street. So what I'm gonna do right now, Mr. Hernandez, what's your email address?
Yes, ma'am. It's Raul 5508 Hernandez @gmail.com.
Okay, you'll receive the order of referral, follow the instructions, and make sure that you communicate with Ms. Olivares' office, okay?
Yes, ma'am.
All right, anything else?
No, Your
We'll
Honor,
see.
that's all. Have a wonderful afternoon.
Okay, thank you. You all are excused.
Thank you for your time.
Thank you, Your Honor.
Okay, sir, TCL 9048S, what is your name, sir? Sir, driving right there, what is your name?
Ismael Valdez.
Okay, and what are you here for?
I got a paper from Mr. Bustos. I had court today. I'm gonna pull over real quick, ma'am. There you go. For child custody, ma'am.
Is the son Damian Galvan?
Yes, ma'am.
Okay, Mr. Bustos has not appeared this morning, sir.
I know, ma'am, and I already called the office, and nobody tells me nothing. I've been dealing with this for a couple of months now, and I know it ain't your fault, and I don't know what to do, ma'am. Like I said, I haven't seen my son in years. I've been paying to get custody for him, and I mean, I don't know. I just need help, and I mean, Mr. Bustos, he does what he does, but I mean, I don't know what to do.
Okay, unfortunately, I can't give you any legal advice or tell you what to do. The only thing I can tell you is that he has not shown up this morning, and so I can't move forward with your motion.
Yes, ma'am.
So, I mean, I'll have my office contact him this afternoon and reset him. But I mean, I can't tell you what to do, sir, whether to stay with their services or not.
No, I mean, I understand that, but like I said, I don't know what's going on. I asked, and a couple of weeks ago, I asked if maybe I can get a paper or something being signed, because Ed Couch PD, or I mean, they don't want to get involved. I mean, trying to get my son. like I said, I have not seen him in a couple of years, and I've been fighting for this. And I mean, I really don't know what I've been doing.
Yeah, I understand, sir, but unfortunately, I can't give you any legal advice. How old is your son?
He's 7, and which, like I said, I haven't seen him in a couple of years. But I mean, every time I try to get him, or I haven't even seen him, and Ed Couch PD, or I mean, they don't. Elsa doesn't want to get involved. I mean, I'm the father. Why can't I pick him up, or why do they get in the middle of me not picking him up?
Unfortunately, I wouldn't be able to tell you as to why. Let me look at something real quick.
I'm just tired. That's it.
I understand, sir. Unfortunately, a lot of this is, I can only do what I can do. And let me see.
I can't believe she's got more rights than I do, and I'm the dad.
Well, sir, don't you have an order from 2015?
Yes, and her mom is locked up right now, and like her grandma has him, and I don't, like I said, I just want to go pick him up. He's my son, and they don't allow me to.
Okay, so the last order that you have is from 2015, but I don't see anything with respect to possession and acts. Oh, there it is. And why can't you use your order that was signed back in 2015?
Because they said that I needed a paper saying that I could pick him up from a judge or an attorney. That's the reason why I hired Mr.
You already have one, sir.
Okay, but every time I tried, well, how do I get a copy?
You come to the courthouse and you're going to ask them for the order that was signed on April 24th, 2015. And you're going to come to the district clerk's window, and you already have that. It says that you have rights for visits.
Okay, but every time I like I said, every time I go to the house, their grandma's house, they're always avoiding me from getting him or even seeing him. And then I have trouble. I have to call the laws and stuff like that.
Okay, sir. All I can tell you is there's an order already saying that you have visits. You can go to the courthouse, get that order, and then show it to the police department. I can't tell you what to do after that or about this case.
I understand that, but does it say there that I like right now, I don't even know if I can pick him up or not, because I don't know if it's my days, but even though the grandma shouldn't have to be involved in all of this stuff. In other words, I think I should have him because I'm the dad. His mom is not there. She's locked up for whatever reason.
Okay, so if the mother is incarcerated and you notified your attorney about that?
Yes, I already told Mr. Bustos, and like I said, I've been asking for a paper for a couple of weeks now. I mean, or something that says that I can pick him up.
So when a parent is locked is incarcerated, then the child does go back to you, but you need to have a modification, which I'm assuming that's what you're trying to do. But you have this document that says that you have your son for the entire month of July. So you have him for Father's Day, and you get him for the first, third, and the fifth weekend. So you need to go and get this paper and try and exercise your rights with the document.
Well, every time I do, the PD says they don't want to get involved.
Okay. I can't do this round and round. I really can't. I've already told you exactly what you need to do. I can't do anything anymore, sir. Hold on. That's all I can do is tell you, go get the order and then go and try and pick up your child, because Father's Day is around the corner and you get all of July. If not, then take the order and take it to your attorney's office and tell him to explain it to you, because I can't do any more than what I've already done.
Yes, ma'am. I'm on my way to go pick up this order because my attorney should have this order. I gave him a copy. But even if it's today, like today is not my day, can I still go try and pick him up, exercise my rights?
No. Today is not your day, like you said. Right now, until you get another document that says that you get him full-time, you can only get him as to how this paper says.
There's no
So,
point. I mean,
I can't do anything about it. I'm not your attorney.
oh my God. I don't know. It's just
So,
frustrating.
okay, so that's all I can tell you, sir. Okay,
That's fine.
good luck to you.
Yes, ma'am. I'll see. Can you maybe help me out and try to get Mr. Bustos? Or I mean, I don't know. He hasn't even called me. I don't know what's going on.
Okay,
Maybe-
we're gonna notify him about this, okay?
Thank you, ma'am.
All
And,
right, thank you.
appreciate your time.
Okay, you too. Okay, so. All right. Okay, on number 19, did they call in for a Rule 11?
Judge, there's a Rule 11 and an order resetting on file.
Okay. And number 26?
26, you gave a reset date of October 10th at 9:30.
No, that was number 27.
Okay.
Judge, on number 26, there's a Rule 11, but we were pending for an order resetting to be filed, so there's no future date, Your Honor.
Okay, so just ask them. And then number 36?
On number 36.
I don't see anything on file, Judge.
Okay, go ahead and set that for the drop docket. Okay, that